Hello everyone, very good morning. Welcome back to Sanjivani. Yes, so today we are going to revise share and share capital chapter. Okay, now this chapter we will be doing from our class notes, okay, as well as from module. Now, if we start with this chapter, see initially in your module also, you can see introduction is given, right? What is a share? What is the meaning of share capital and all those things, right? So you know that what is a share capital? Capital which is raised by the company by issue of shares, right? And there are kinds of share capital, right? One is equity share capital, another is preference share capital. Yes. What is equity share capital? Capital which is raised by the issue of equity shares. Preference capital? Capital which is raised by the issue of preference shares. Very simple. You know what is preference shares? The preference shareholders enjoys priority. Enjoys priority on what? In two things. Okay. One is payment of dividend and second is repayment of capital, right? In both those things. And equity share capital is further divided into two categories. One is equity share with pari-passu rights and second is with differential voting rights. What is pari-passu rights? Equal rights. Like you can see one example here. Suppose there is a company ABC Limited, okay, and there is one shareholder of this company. Now this shareholder is having one dividend right and one voting right. Another shareholder of the same company is again having one dividend right, one voting right. Now you can see all the shareholders of that company have equal rights. So it is called as what? Pari-passu rights. That is equal rights. Okay. But the another category is differential rights. Now, for example, there is a company XYZ Limited. Okay. There is one member, there is shareholder. He is having two dividend right, one voting right. Okay. Another member of the same company is having one dividend right and three voting rights. Now you saw in the second company the rights are not equal. That is differential voting rights. So there are two categories basically. Okay, so I hope this is clear to everybody. Yes, now here also in your module you can see the definition of share, right, which you people are doing from, I guess, after your school. Right, what is the share? So share means share in the share capital of the company and it includes stock. Okay, then you can see the share capital and what are the different classes of share capital. Very simple. You can see authorized capital, issued capital, subscribed capital, called up, paid up, unpaid up, uncalled up. All these are the categories, right? So all these definitions are given here. Yes, just to revise once. Chalo, what is authorized capital? So authorized capital is the maximum amount what company can raise by issue of shares. Let's say, for example, my company MS Limited is having authorized capital of 1 CR. 1 crore rupees. Authorized capital of 1 CR. So what does this mean? 1 CR is the maximum amount what my company can raise by issue of shares. My company cannot raise more than 1 CR. Okay, if my company wants to do that, can my company increase the capital, authorized capital? Yes. Now see, where will you find this maximum amount? Where is this amount mentioned? This amount is mentioned in your MOA in capital clause. So obviously, can you alter capital clause? Yes, that you have studied in your chapter MOA and AOA and its alteration. So by following the procedure of alteration, you can alter this and increase the limit also. Okay, but yes, it is authorized capital. This is the maximum amount what company can raise. Now suppose if my company is in need of only 2 lakh rupees. So in that case, will my company issue shares for 1 CR? No. My company needs only 2 lakh rupees. So therefore, my company will keep the shares of 2 lakhs only in the market for sale. So the amount is 2 lakh rupees. The amount is 2 lakh rupees. So what is 2 lakh? This amount 2 lakh rupees is called as what capital? This is called as issued capital. Okay, so what is unissued? The remaining one is unissued, that is 98 lakhs. This is unissued capital. Okay, now my company has kept shares for sale worth rupees 2 lakh, right? But now people may buy the shares, people may not buy the shares. That is, people may subscribe, people may not subscribe, right? So now out of this 2 lakh rupees, shares of 1 lakh 95,000, shares of 1 lakh 95,000 were subscribed by the investors. Okay, means this many shares were sold in the market, people purchased so many shares. And what is the amount which was not subscribed? That is 5,000 rupees, that was not subscribed. So 1,95,000 is called as what? Subscribed capital. And what is unsubscribed capital? This is called as unsubscribed capital. Okay, clear? So subscribed and unsubscribed, 1,95,000. Now this many shares were subscribed. Now obviously those who are subscribing the shares will have to pay money because they're subscribing the shares. So first company is going to give a call. Kindly pay this much money, this money, call first call money, this money, that money. So out of 1,95,000, there can be certain amount which company has given a call for. Like as you know, there is something called as application money, then there is allotment money, then there is first call money, then there is second and final call money. So if the price of the share is 10 rupees, application money is 2 rupees, allotment money is 2 rupees, 3 rupees, first call is 2 rupees, and second and final call is 3 rupees suppose. So total amount of share is 10 rupees. Now out of this, company has asked the investors to kindly pay 7 rupees. That is 2 plus 3 plus 2. So 7 rupees is called up. Means call is given by the company. Kindly pay this money. So obviously to whom we are going to give the call? The people who have subscribed our shares. Right? So 7 rupees into number of shares issued by the company or subscribed by the investors. This amount total is going to be called as called up capital. Yes or no? The amount which company has given call for. This is called called up capital. Okay. Now tell me, what is uncalled capital? The amount for which company has not yet demanded the amount. That amount is 3 rupees. That is called uncalled capital. Okay, now what people will do? Obviously we have given a call, so people will pay the money. So out of call, obviously we have not called the money. If we have not called the money, will people pay? No, because we have not asked for it. So we have asked for 7 rupees per share. So what do you think? The entire amount will be paid to us? That is not necessary. The number of shares issued by the company, okay, into 7 rupees per share, no? So total amount what company may had received, out of that there is a certain amount which company has received and there is certain amount which company has not received. So amount which is received by the company is called as paid up capital, and company has not received the next amount, that is called as unpaid capital. Okay, so all these terms are already explained here. You can see subscribed capital, called up capital, paid up capital, right? That is authorized capital, which is also called as nominal capital, registered capital, or these things. Issued capital you can see here. Okay, so this is the kinds of capital. Then just now I explained you here in my notes, that is types of share capital, that is equity and preference. So here you can see equity capital and preference share capital. Then I told you equity shares are further divided into two categories, and then preference share enjoy two things: repayment of capital and payment of dividend. They enjoy priority in these two things. Okay, yes, these are the categories of share capital, types of shares, that you have done all this. Then can you see this voting rights? Voting rights of this share capital. One is equity shareholders, second is preference shareholders. Now here we are talking about section number 47, which you people have already done. Where? In your chapter members and shareholders. You have this section over there as well. Okay. So yes, what do you think? What are the rights of equity shareholders and what are the rights of preference shareholders? You know, equity shareholders can vote in on every resolution. So equity shareholders can vote, have right to vote on every resolution placed before the company. But tell me, can preference shareholders vote on every resolution? Answer is no. They have right to vote only on those resolutions which are placed before the company, which directly affect the rights of their rights, means rights attached to the preference shares. Okay, so they can vote only on such matters which affect their rights. Otherwise, they cannot vote on every matter. Equity shareholder can vote on every matter. Okay, yes, but there are certain circumstances where preference shareholders have voting rights. So, which are those circumstances? So, here you can see if there is a resolution put up for winding up of company. If there is a resolution required to be passed by the members for winding up of company, in such resolution, preference shareholders can vote. Then repayment or reduction of capital. So in that case also they can vote. Okay, but not on every matter. Now when we talk about voting rights by poll. So what will be the voting rights by poll for equity shareholders and for preference shareholders? Now we know voting by poll means what? One share, one vote. So how much voting rights they will get? Can I say that depends on their proportion of shareholding? Yes. So here you can see voting rights on poll shall be in proportion to his shares, that is paid up equity share capital of the company. Same goes here also. Voting right by poll shall be in proportion to the shares in the paid up preference share capital of the company. Right? Very simple. So that depends on their shareholding. Okay? But yes, now there is one more thing here. See this. Where dividend is not paid to preference shareholders, okay, for a period of 2 or more years, if dividend is not paid to them, such preference shareholders have right to vote on all the resolutions now. Generally we told they cannot vote on every resolution, right? But if they have not received, if the dividend is not paid to them for 2 or more years, so now they have right to vote on every resolution. Okay, so this was your section number 47. Okay, easy everybody? Yes, yes, and here then part B starts. We will come to part B, but let's go with this part first. Have you understood this kinds of share capital? What is a share? What is a share capital and so on? Okay. Now here in module part B is getting started. Now in part B here again you can see few definitions. So definitions of securities. You know security is a wider term, it includes everything: shares, debentures, bonds, everything. Okay, then the topic is prospectus. But yes, I will be doing prospectus topic once I finish certain part of it, certain part of the chapter. So don't worry, we will be doing types of prospectus from module only. Okay, but after this, now next we can see after all the types of prospectus, here there is share certificate, and then we need to go. What I have done is in my notes, I have followed a different sequence. Okay, nothing else. You will see share capital in my notes as well. So once we are done with that, or what I can do is I can first go with this, then we will search there. Come on. So after share capital, next topic we are starting is general principles of allotment of securities. What are the basic rules of allotment of securities? Now just now we saw the definition of securities. It's a wider term. It includes everything. Correct? No, beta, I told you clearly, preference shareholders can vote on the matters which affects their interest only, correct? But if they have not received dividend for 2 or more years, then they can vote on every resolution. Okay, all the resolutions, yes. Okay, come on, let's go. Now, principles, general principles of allotment. Now, whenever we talk about the allotment of shares, always we are going to follow the general principles. So what are the rules for allotment? This topic in your module, you can see it is given concept of allotment of securities, you can see, and here is the general principle regarding allotment. Okay, so this we are going to do right now from my notes. Let's go. So yes, come on. Allotment of securities shall be done by whom? Come on, who does the allotment? Obviously board. So allotment is done by the board of directors or committee of board. Okay, so who does the allotment is very clear to everybody. Okay, chalo, next. Allotment must be done within how much time? Allotment must be done within 60 days from the date of receipt of application money. Friends, you know when we apply for the shares, company have to make the allotment within 60 days. If company does not make the allotment, see if company does not make the allotment within 60 days, then company have to refund your application money within next 15 days. Okay, clear? So this is your first point as per my notes regarding the general principles of allotment. Come on, what is next? Allotment of shares must be absolute, that is unconditional. Means company can't say that we will allot you the shares if this happens. We will allot you the shares if we get so and so amount from so and so thing. We will allot you the shares if this new project is cleared. So you can't be conditional in this case. Allotment has to be absolute. That is unconditional. Okay. Next, it shall not based on any event which is uncertain in nature. As I gave you the example that company will make the allotment of shares if this happens, so it cannot be uncertain. Okay, so it has to be unconditional. Okay, and it should not be based on happening of any event. Next, company shall allot the shares, okay, only and only when written application is given to the company, okay, and where the person agrees in writing to become the member of company. Okay, so company will make the allotment only when company receives an application in writing and person agrees in writing to become the member of company. Second, whenever company makes the allotment, company must communicate to allottee. Means company must communicate to the investor by sending letter of allotment or share certificate. You must have heard about this letter of allotment, that is confirmation of allotment, or share certificate. Share certificate, that is ownership document. Correct? Yes. Next is allotment should not contradict the provision of any other law. It should be as per the compliance requirement. Okay. Next, in case of public issue, you know what is public issue? Offer is being made to the general public. Right? In this case, allotment shall be made only on receipt of minimum subscription of 90%. This is very common, you must have heard many times. Company should receive minimum 90% subscription, then only company can go for allotment, because that is a minimum requirement. Then on allotment of shares, once the allotment is done, now what shall company do? You know, always company have to file a return of allotment. Means company, after every allotment you will see this form. This is form PAS 3. Always you will see this is return of allotment which company needs to file to ROC, authority, that is ROC, by filing form PAS 3. What is PAS? Prospectus and allotment of shares. Within 30 days of allotment. Okay, once the allotment of shares is done, within 30 days company have to file this return with ROC. Yes, next. Now what you are going to mention in this PAS3? What shall be written in this? So you need to give, company is going to give the details of allottees to whom the securities are being allotted. Because as you know, we have done that in the deposits chapter. Company will file the returns in form DPT3, giving the details of all the depositors and how much amount company has received, how much rate of interest. So similarly here we are giving the list of allottees, that is list of investors, how much, which type of securities are allotted to them, what securities, when issued, everything. So return is to be filed with ROC. Next is, if company allotted shares for a consideration other than cash. What is this? See, why company is issuing shares? Because in return company wants money, capital, right? But there are issue of securities for a consideration other than cash also. Means many times you must have seen that company in return, company does not get capital, but company gets some property. Let's say for example intellectual property, right? Company has received some services, right? Means whatever consideration company is getting instead of cash, that can be in the nature of asset or it cannot be in the nature of asset. Example, if company has issued shares and in return company is getting some property, let's say for example in intellectual property, so that is in the form of asset. But there can be situation where company is allotting the shares because company has received some services from that person in return. So instead of paying him his fees, company is allotting shares. Now tell me, whatever company has received, is that an asset? No. So in this case, we will treat that expenditure. The amount what we are spending for this shares, the value of shares shall be treated as a expenditure for such services what company has received. So here we are talking about principles of allotment. If company has made allotment of shares, in return company has not received capital, company has received what? Consideration other than cash. So what is to be done? So for that there is an additional requirement. So whenever you get consideration other than cash, and when you will file this return of allotment in form PAS 3, in this what you need to do is you need to attach a copy of contract duly signed and stamped with regard to which securities were allotted along with the contract of sale of service. See, understand one thing. I told you, if company has received what? Company has received a property in return, or if company has received some services in return. So obviously there must be some contract between company and that party regarding that providing services or transfer of property, right? So when company is making the allotment of shares and in return if company is getting some property or some services, and when that allotment is done, company is going to file PAS 3. Correct? So when company is going to file PAS 3, along with that company have to attach the copy of that contract, copy of that transaction. Obviously this is possible if the contract is in writing. But what if contract is not in writing? How will you, what will you attach along with the returns? Okay, so if it is in writing, you need to attach the copy along with the returns. But if it is not in writing, then what to do? If it is not in writing, then company will provide the entire details of the transaction in writing. Okay, see, if there is a contract in writing, you need to attach the copy of contract. But if it is not in writing, then what you will do? You will give it in writing, complete details of the contract with the same stamp duty which would have been paid if the contract had been in writing. Okay, means you will give it in writing and attach the same copy with form PAS 3. Is this clear? Okay, this is the thing. So next, what's next? Next is whatever you have written in, whatever you have received in return as a consideration. So obviously their law says that whatever company gets in return, that thing, that service, that property, that consideration must have such value. Like company has allotted shares, value of which is 1 lakh rupees. So in return company should get consideration of 1 lakh rupees value. So similarly here we are saying that we need to first determine the value of that consideration what company is getting. So who is going to identify the value of that something in return? Registered valuer. Correct? Registered valuer. So here you need to attach the valuation report also along with PAS 3. That is along with the returns. Okay, so attach the valuation report issued by registered valuer with regard to valuation of consideration. Okay, so in that case, you will attach this as well. Easy. Now, if company has issued bonus shares, okay, then copy of ordinary resolution passed in general meeting shall be attached with the returns, that is pass 3. Have you understood this, what I'm saying? Everyone, see this once again. When the company is making allotment of shares, company have to first, what company have to do? Always company have to, after every allotment, company have to file the returns of allotment in form pass 3. Okay, that is return of allotment, that is within 30 days from the date of allotment with ROC, which contains the list of allottees. The next point, if company has allotted shares for a consideration other than cash, and in that case, what company needs to do? Company need to attach the copy of contract if it is in writing. Company need to attach the copy of contract along with the return copy, that is pass 3. And if the contract is not in writing, then what to do? If contract is not in writing, then company have to give the particulars of the transaction in writing, okay, along with the stamp duty in the same manner as if the contract was originally entered in writing. And you need to attach this copy with the returns of allotment, pass 3. And if company is issuing bonus shares, so for bonus shares you need to pass ordinary resolution, correct, in general meeting. So you need to attach a copy of ordinary resolution along with the pass 3. Okay, done. So all these points are very clear. Okay, what is next? Next is whatever application money we ask for the shares, okay, to subscribe for the shares, to apply for the shares, what shall be the amount of application money? The amount of application money shall be 5% of the nominal value of shares. At least 5% of nominal value of shares, or such a higher amount as prescribed by SEBI. Okay, and you know that if minimum applications are not received, then what shall company do? Company have to refund the entire share application money. Okay, so friends, here in 6 points we are done with the general principles of allotment. You will find the same thing in your module here also. Okay, yes, first point what we did, who makes the allotment? The allotment must be made by proper authority, that is by board or committee authorized by board. Yes or no? Then allotment must be made within reasonable time. What is that time? 60 days. And if it is not made, then what company is to do? Company needs to refund the share application money. Then we did allotment should be absolute and unconditional. We did that, right? Then allotment must be communicated. You know, I told you by letter of allotment or by share certificate. Then allotment against the application only. I told you company cannot make the allotment unless company receives what? Application in writing. Okay, that member should agree to be the member of company. Next is allotment should not be in contravention of any other law. Okay, yes, and also allotment should not be made to the minor. This you have done in your chapter members and shareholders also. Okay, clear everybody? Yes, so we are done with all these points of allotment. What is the next topic? Next topic is issue of shares on premium. Same topic here also you can see in your module. Okay, here they are given first private placement. The sequence is, can you see this concept of allotment, which I told you the minimum amount of application money, that is 5%. Then you need to attach this pass 3, right? If you get consideration other than cash, then what is to be done? You need to file this return along with this details of allottee, right? Then if it is consideration other than cash, then what is to be done? If the contract is not in writing, then what is to be done? Right? So all these things we already done. Then you need to refund the money if company has not received the minimum subscription, right? And if any default is made, then there is a penalty. Okay, so all these points are also done, and here you can see the general principle points are also done from your module. Okay, same thing. And next topic is now issue of shares at premium. Here it is. Okay, easy. Now see how these notes are in line of your ICSI module. So we are talking about which section right now? Section number 52. Issue of shares at premium. Come on, what is this issue of shares at premium firstly? Whenever a company is issuing shares at a price that is higher than, sorry, higher than face value, correct. So friends, if it is issuing shares at a price more than face value, then it is called as what? It is called as what? Issue of shares at premium. Okay. Okay, here there is one doubt. Yes beta, here clearly it's given. मैंने आपको बोला. See, it is, can you see this? 5% of the nominal value or such other as specified by SEBI, correct? So whatever prescribed by SEBI, that or 5%. Okay, Aditya. So you are writing answer as per Companies Act. So we are writing 5%. But yes, you need to write this way, 5% or such other percent as prescribed by SEBI. Okay, chalo, let's continue. So yes, issue of shares, that is issue of shares at a price that is more than the face value is called as issue of shares at premium. So let's say for example the price of face value of shares is 10 rupees, but company is issuing shares at 12 rupees. So is company issuing shares at a price that is more than the face value? Yes. Now tell me how much amount company is going to receive? 12 rupees, right? Okay, now tell me the 12 rupees what company is getting, that amount shall be credited to which account? 12 rupees. 12 rupees is share capital? No, share capital is only 10 rupees. 2 rupees what company is charging, that is premium money. Okay, so 10 rupees shall go to share capital account and 2 rupees into securities premium account. Easy. So that way 12 rupees is going to be there. Here you can see 10 rupees and 2 rupees. Okay, now in this section 52, whatever amount you have received in the form of premium money, that shall be into securities premium account. But here there is a rule related to utilization of the amount in securities premium account. You need to learn these points. So securities premium amount shall be utilized for the following purpose only. For which purposes? Here you can see there are 5 points. First is you can use this money for issue of fully paid up bonus shares. See, company is issuing bonus shares. So obviously bonus shares means company is issuing shares free of cost. Is company going to get any capital for that? No. So if company is issuing bonus shares, tell me, will the share capital of company increase? What do you think? Obviously, will number of shares increase? Number of shares allotted will increase or it will not increase? Number of shares. Earlier, company had issued 1 lakh shares. Now company has given 10,000 bonus shares also. So what are the number of shares in the market? 1 lakh only. 1 lakh 10,000. Earlier company had issued how many number of shares? 1 lakh. Now company gave shares free of cost, how much? 10,000. So total number of shares issued allotted by the company is how much? 1 lakh 10,000. It increased, right? So here obviously share capital will also increase. But is company going to raise money? Is company going to ask for the money? No, it is bonus shares. So where will the money come from? Company can utilize the amount of securities premium money into for issue of fully paid up bonus shares. This money can be utilized for this purpose. Okay. Second, to write off pre-incorporation expenses. What is this pre-incorporation expenses? You know, before the company was incorporated, there was some before incorporation procedure that was done by the promoter of company, right? Let's say for example, whatever property they are going to purchase, if they hire some professional to follow the legal procedure for incorporation of company, whatever contracts are required to be done for incorporation of company, all those contracts will be done by the promoter. So whatever expenditure that promoter is incurred for incorporation of company can be taken out from securities premium account. So this money can be utilized for to write off pre-incorporation expense. Then write off preliminary expense, discount, commissions on issue of shares and debentures. Okay, we give commission money to underwriters, correct? So this amount can utilize for that purpose also. Oh, I forgot it's the revision class. Why I am going so much in detail? Otherwise we won't finish the chapter. Sorry. Yeah, I assume you have studied this chapter once, huh? Correct? So there are 5 points basically. First point, you can use this money for issue of fully paid up bonus shares. Second, write off pre-incorporation expenses. Third, you can utilize this money for writing off preliminary expense, discount, commission on issue of shares and debentures. Okay. Then buyback of securities. You know what is buyback of shares? Company purchase back its own shares. Buyback of shares. So for that purpose, obviously the investors are not going to give you shares. They will not allow you to buy back the shares free of cost. You need to pay money to them. So that is called buyback of shares. You can give the money from securities premium account. Then write off premium on redemption of preference shares. You know preference shares are redeemed. Yes or no? If the price of the share is 20 and company is going to redeem, means again buyback only. For preference shares we use the word redemption. But company is in a way, what company is doing? Company is buying back the shares, preference shares, which is called as redemption of preference shares. So company is redeeming the preference shares on premium. Means company is not going to pay 20 rupees, company is going to pay 25 rupees for example. So is company paying 5 rupees extra? Yes, company is paying 5 rupees extra. So if company is paying 5 rupees extra, that amount is premium money. So that amount can be taken out from securities premium account. Only premium amount can be taken out from securities premium account in redemption of preferences at premium. Okay. Next is, so these are the 5 points. I hope this is clear to everybody, right? Then the amount which is there in securities premium account, this is not a part of free reserves. You know there is a definition of free reserves given in Companies Act, section 2 clause 43. So which excludes what? Securities premium account. Therefore it cannot be utilized for dividend purpose. Securities premium account cannot be utilized for dividend purpose, because you know what, only one reserves can be used for dividend, that is free reserves, and securities premium is excluded from free reserves, therefore cannot be used for the purpose of declaration of dividend. Is this clear to everybody? If you utilize this money of securities premium account, if this money is utilized for any other purpose, then it shall lead to reduction of share capital. Friends, you know what is reduction of share capital? It will be treated as if share capital is going down. If you utilize this money for any other purpose, that will reduce the share capital, and whenever the share capital is reduced, see there are two things. One is reduction of share capital, another is diminution of share capital. What is the difference? In both the cases, share capital goes down. But one is named as reduction of share capital and another is named as diminution of share capital. Sir, what is the difference? Difference is there are few circumstances which are considered under reduction of share capital. There are few circumstances where share capital is going down and which are put into the second category, that is reduction of share capital. And there are few circumstances which are put into the first category, that is diminution of share capital. So sir, now what to do? See, whenever the circumstances which are covered under reduction of share capital, for this purpose you need to follow section number 66. And if there is a circumstances which are part of diminution of share capital, there you don't have to follow 66. Understood? Because it is not reduction of share capital, it is called as diminution of share capital. So here we are saying that if the amount is used for any other purpose, amount of securities premium account is used for any other purpose, so it shall amount to what? Reduction of share capital. Means your company is required to follow section number 66. Easy? Okay? You know what? Your section 52 is over. From your module, it is over. Yes, if you have module in front of you, yes, can you see this? Issue of shares at premium. Here. So in first para they have given you the meaning. Whenever company issue shares at a price above the nominal value, and there are few conditions for issue of shares by the company at premium. Okay, so what it is? Here you can see in this way you can do it. That is securities premium account. The amount which is raised, I told you the share capital money will go into share capital, the premium money will go into securities premium money, and securities premium money can be utilized for this purpose which we did just now, correct? And yes, then you can see here points to remember, simple explanation is given there, and then here the next part will start, that is issue of shares at discount. Okay, the points to remember and everything what you saw, that covers these parts. Okay, so here also we are going to the next part, that is issue of shares at discount. Okay friends, come on, now tell me, this is section number 53. Are you comfortable with these notes? I will put the link in the comment section. Okay, yes, and I will put the link of all my notes in the comment section. Now you may face difficulty in your mobile phone for opening these notes, but you have to wait and be patient, that these files are very heavy, so it may take 1 minute to load it, but it will open, don't worry. Or you can also download that app WPS in your mobile phone, it will help to open these files. Okay, let's go. So issue of shares at discount. Now what is this? Generally company cannot issue shares at discount. Generally it is not allowed to issue shares at discount, but there are exceptions. What are the exceptions? Two exceptions. First, sweat equity shares under section 54 is allowed to be issued at discount. And secondly, if company is issuing shares at discount to its creditors when the debt is converted into shares with regard to the resolution plan or debt restructuring scheme in accordance with RBI Act or Banking Regulation Act. Sir, what is this? Come on, firstly, basic, what I told you, section 53, issue of shares at discount is not allowed. But there are exceptions. When I say exceptions, means it is allowed. Right? So first thing which is allowed is sweat equity shares. What are sweat equity shares? We are going to do that. We have that topic in our module in this chapter. So issue of sweat equity shares allowed at discount. And secondly, whenever the shares are issued at discount, that is to its creditors. Why? That is when the debt is converted into shares. Okay, with regard to resolution plan or as per debt restructuring scheme. Now what is the second one? First is clearly everybody understood, by that is in case of issue of sweat equity shares. What is the second one? Suppose if company have to make the payment to its creditors and company don't have that much money. So what company did? Instead of making the payment, what company did? Yes, what company did? Company issued shares to the creditors. Understood? But we are talking about issue of shares at discount. Sir, practicality क्या है? Understand, I'll explain you why this is allowed at discount. Suppose if company wants to pay you 10 lakh rupees. Okay, if company wants to pay you 10 lakh rupees. Okay, now company don't have money. So what company did? Company will issue you shares. What company told you? Hey, don't worry, I will give you shares worth rupees 10 lakhs. Suppose, listen carefully. So company is giving you shares instead of money. Shares worth rupees 10 lakhs. Come on, tell me, happy, not happy? You are happy or you're not happy? You're not happy because you are getting the shares. You said, no, I don't want this. I want money. I want cash. I don't want shares. But what if company tells you, I will not give you money. Instead of money, I will give you shares. Okay, and I will give you shares worth rupees 11 lakhs to adjust our debt, which is of amount 10 lakh rupees. Are you getting my point? So we are setting off the debts. We are finishing off the debts by allotment of shares worth rupees 11 lakhs. So can I say you got shares of a higher value than the actual amount of debt? Are you happy now? Yes. Tell me, are you getting shares at discount? Yes. You got more number of shares. You got more number of shares at a price of 10 lakhs. You understood? So that in that way it is allowed. That is the logic. Understood now? Everybody understood? Yes. So in this way it is allowed. Come on. Issue of shares at discount is not allowed generally. But when we talk about sweat equity shares, it is allowed. And whenever it is given to the creditors to adjust the debt. Okay? 2 points. Now, if company makes allotment of shares at discount in any other way, such allotment shall be void. Okay? And next is company. Generally we told company cannot issue shares at discount, right? But company can issue debentures at discount. Company can issue what? Debentures at discount, and also forfeited shares which are reissued. So this can be done at discount. But otherwise company cannot allot shares at discount. Is this clear to everybody? Yes, next. If requirement of this section is not complied, then there is a penalty. So here is the penalty you can see. Okay, then this section is over. Easy. You know what? We are done with this section 53, everything from your module. See, it's only this much. Yes or no? See, what I told you is, generally company shall not allot shares at discount. Any shares issued by the company at discount shall be void. But obviously there are exceptions. What are the exceptions? First, if company is giving sweat equity shares. Okay, so can you see this? Except, can you see this? Except which is given in case of section 54. That is sweat equity shares. That becomes your first exception. And second exception is company is issuing shares at discount to its creditors where the debt is converted into shares as per debt restructuring scheme, right? As per the directions or regulations by RBI under RBI Act or Banking Regulation Act. And if company fails to comply with the requirement of the section, so there is a penalty. Very simple. Everybody clear? Yes. Okay, so we're done with 52 and 53. Come on, what's next? Now we are coming to 55. 54 we will be doing sweat equity shares, but we are just following the sequence as per my notes. Come on, let's go. What's next? Now we are going to talk about issue of preference shares and then redemption of preference shares. In your ICSI module, they have given both of the topics as combined issue as well as redemption. So what I'm going to do is first we will talk about issue of preference shares and then we'll talk about redemption of preference shares. Okay, let's go. So yes, can you see the points here? 1, 2, 3, 4, 5, 6. Follow the points and it's done. Come on. Firstly, if company wants to issue preference shares, this can be done only and only and only when company is having authority to issue preference shares in its articles of association of company. You understood? Yes, the power to issue preference shares must be allowed in AOA. Only then this is possible. If authority is not given in AOA, can we alter AOA? Yes, we can alter AOA by passing special resolution and then we can go for issue of preference shares. Easy everybody? Simple? Come on, second point. So this was passing SR for alteration of AOA. But what if our company's AOA already gives power to issue preference shares? Then what to do? Can we go for issue of preference shares? Yes, but for that you need to pass special resolution. For issue of preference shares, company needs to pass special resolution at general meeting of the company. Is this clear to all? Everybody understood this? So why was this SR for? This was for alteration of AOA. This is for issue of preference shares. Means can I say SR is compulsory? Yes. Now this special resolution, the draft of the resolution shall specify all the terms of issue of preference shares. It shall contain all the details of the issue. Okay. Next point is, at the time of issue of preference shares, okay, company should not have made default, or default must not subsist with regard to redemption of preference shares earlier allotted, okay, and payment of dividend. So company has done if any of this defaults, and if this default subsists, then company cannot issue preference shares. Okay, easy. Now this was the third point. Now point number 4, whenever company is issuing preference shares, tell me, the preference shareholders are also the members of company? Yes or no? Preference shareholders are also the members of company? Yes or no? Yes. So are we going to enter their details in the ROM? ROM means which format? MGT1. Form number MGT1. Okay, so details of such shareholders are also entered in the ROM. Clear? Any doubt in this? Fourth point. Now fifth point. Now as I told you, we need to pass SR at the general meeting. For general meeting you need to give the notice of meeting. Yes or no? So when you are going to give the notice, along with the notice of meeting, you need to attach explanatory statement specifying the details of such issue. So specify all the details, then voting will be conducted, and accordingly resolution will be passed if company gets the required votes. Okay, now this was about the issue, and redemption of preference shares must be done as per the issue terms only. Okay, if company wants to alter its this terms and conditions, then company needs to comply with section 48. What is 48? Variation in the rights of shareholders. 47 was voting rights. 48 is variation in the rights of shareholders. For that also you need to pass SR. Authority must be given in AOA, right? Then you need to take the consent of the 3/4 of the that category. That is, let's say for example, preference shareholders. Basically, there is an entire section for that. This section you have done in your chapter members and shareholders. 47 and 48 both. Okay, easy. So how many points? 6 points. One more time. One last time. Come on. For issue of preference shares, first requirement is authority must be given in AOA. If authority is given in AOA, then you need to pass SR for issue of preference shares. What if authority is not given in AOA? You can alter AOA by passing SR. Then what to do? Then pass SR for issue of preference shares. Correct? Yes. After that, third point, at the time of issue of preference shares, at the time when company is making that issue, company must have not made any default with regard to this and this, redemption of preference shares and payment of dividend. And even if company has made the default must not subsist at that time. Correct, everybody? Yes. Then point number 4, whenever company is making the issue, their details of such type of shareholders are also entered in ROM, that is form MGT1. And whenever we give the notice of general meeting to pass SR, you need to also attach, along with the notice, you need to attach explanatory statement specifying the details of such issue. Okay, then we spoke redemption must be done as per the issue terms only. If you want to change the terms, you need to comply with the requirement of section 48. We are done with it. Yes, let's go. See, this is general principle of allotment. This is private placement, issue of shares with DVR, and here is issue and redemption of preference shares. Okay, done. But here, as I told you, what they have done is issue and redemption both are written together, combined. Okay, so once you read my notes, after that you read this, it will directly match, okay, everything completely, because here they're talking about the both the things. Okay, here it will end, and here then there is a procedure. Then we will talk about 62. Okay, so let's go with this redemption part now first. Come on, redemption of preference shares. Firstly, tell me what to redeem. What we are talking about to redeem? Redemption of preference shares. Which preference shares can be redeemed? Only fully paid up preference shares can be redeemed. Can I say redeem means it's like a buyback only? So if we are going to redeem it, we need to pay money. So from where we, how to redeem? Sources. So you can redeem means you can pay money out of the profits of company. Okay, profits means company creates a separate account called as CRR account, that is capital redemption reserve. So you can pay money out of that. So it's out of profits. Or another option is out of the proceeds of fresh issue made for the same. What is this? Means if company wants to do the redemption of preference shares, for that company needs money. Company don't have money. So what company will do? Company will go for fresh issue. So company will make the issue of new shares, money will be raised, and that money will be used in redemption. Okay, so out of the proceeds of the fresh issue made for the same. So company redeems out of the fresh issue, for which here no CRR is required to be created. Come on, once again, what are we talking about? Redemption. Which preferences can be redeemed? Only fully paid up preferences can be redeemed. Correct? Out of what? Money will come out of what? Money will come out of the profits, that is from CRR account, or out of the proceeds of fresh issue, which is done for the same. Clear, everybody? Yes, so this was the source from where the money receives. Now tell me one thing, when we do the redemption of preference shares, can I say the number of shares in the market will decrease? The number of shares of our company will be reduced in the market. Earlier we were having share capital of 1 CR. Now we have done the redemption of preference shares of 10 lakh rupees. So can I say now the share capital of company will also decrease? Yes or no? So whenever the amount of share capital reduces, this will be called as what? This can be either called as reduction of share capital, or it can be called as diminution of share capital. You know the difference? I told you. If there are circumstances, there are few circumstances which are covered under which category? Reduction of share capital category. And there are few circumstances which are covered under diminution of share capital category. So what is the difference? If there is circumstances which leads to reduction of share capital, for that company is required to follow section number 66. I told you that. And if there is a circumstances which is not covered in diminution, in that case, if it is covered in diminution, in that case you don't need to comply with section number 66. Understood? So what is section 66? That is nothing but NCLT approval procedure. For reduction of share capital, you need to comply with NCLT approval procedure. Okay, so here tell me, by redemption of preference shares, are we going to redeem? Are we going to reduce the share capital? Yes, we are going to reduce the share capital. So will this lead to reduction of share capital, or it will lead to diminution of share capital? What will it lead to? Let's see. Here it is. Such reduce in share capital of company. Yes, for by redemption of preference shares, it reduces the share capital of company. But NCLT approval is not required, as section 66 is not applicable. Why? Because this is called as diminution of share capital and not reduction of share capital. You understood? This one is named under what? Diminution of share capital and not reduction of share capital. Sorry? No, it is not that. There are few circumstances which are already that bifurcation already given. We will be doing that in 66. That so and so circumstances are this. So for that, what you need to do? You need to comply with NCLT approval rules. Understood? There is a procedure for NCLT approval, so you need to do that. So what is the logic? They says that you can reduce your share capital only where it is permitted. Like you saw that this previous section what we did, issue of shares at premium 52. Securities premium amount should be used only for these five purpose. If you use it for any other purpose, it will lead to reduction and not diminution. It will lead to reduction. Understood? Because which is not a diminution. Understood? Yes. Will we do that? We'll do that today. ठीक है. Okay. आएगा इसमें भी आगे. Tension मत लो. But have you understood what I told you? See, we are talking about falling in share capital. We are talking about fall in share capital. But fall in share capital means share capital is going down, means reduction. But there are many reasons by which share capital goes down, by the way. Buyback of shares, redemption of preference shares. There are many reasons. Now, there are few reasons which are covered under reduction of share capital, and there are few reasons which are covered under diminution of share capital. So what is the difference? Difference is the circumstances which are covered under diminution of share capital, which are called as diminution, like this one, redemption of preference shares. Here the share capital is going down, yes, but what this is called as reduction or diminution? Diminution. So now what to do? So in this case section 66 is not applicable. So what is not required to be done? There is no need to take the approval of NCLT. And the things which are covered under reduction of share capital, there section 66 is applicable, means NCLT approval procedure is to be followed. That's it. You understood this much? Everybody? Clear? Okay. Fine. Now, if the preference shares are redeemed at premium, I told you, you are paying more than the price. So, from where you are going to take the amount for redemption of preference shares? From where you are going to take the amount for redemption of preference shares? That is out of profits, that is CRR, or out of the proceeds of fresh issue, correct? But the premium money, as I told you, 20 rupees plus 5 rupees. 5 rupees you are charging as a, not charging, you are paying as a premium. This money you can take out from securities premium account. Everybody understood? Yes? Yes. That's all? All the points are done? Yes? See this now. As per Companies Act 2013, okay, section 55, company limited by shares cannot issue irredeemable preference shares. You know there are types of preferences, redeemable, irredeemable. So irredeemable preferences cannot be issued now. Okay, redeemable, you know, company is going to repay your money back, but irredeemable means company will not repay your money. Company will repay your money, but only when company goes into winding up. So now these types of shares cannot be issued as per Companies Act section 55. Okay, now we are talking about the tenure. Come on, what is the tenure for preference shares? So generally company limited by shares may issue preference shares. Company limited by shares may issue preference shares within a period not exceeding 20 years from the date of issue. Means company will redeem the preference shares. Company will issue preference shares for maximum 20 years. Company have to redeem within the period of 20 years. Okay, but you know what? There are few companies which are involved in infrastructure activity. Firstly, what is infrastructure activity? Activities which are given in schedule number 6. Okay, so can I say infrastructure activity means companies raising money for infrastructure activity, means they have basically long-term projects. So for that the requirement of funds can also be long-term. So therefore for such companies, company can raise money for, company can issue preference shares for a period of more than 20 years also? Answer is yes. Yes, can issue preference shares which are liable to redeem for a period exceeding 20 years, that is more than 20 years, but not more than 30 years. More than 20 years allowed, but not more than 30 years, also with a condition. Condition number one. Condition number one. Suppose if, for example, company has issued preference shares for 30 years. So is it more than 20 years? Yes. So it is 30 years, okay? So redemption of preference shares may be made from 21st year onwards. Means you have given for 30 years. So 21st year onwards, company should start with redemption. 21st year onwards, like every year, company have to do the redemption every year. How much? At least 10% redemption every year. So till 20 years, no problem. But from 21st year onwards, 10% shall be redeemed by the company. If you satisfy these conditions, then 30 years is allowed, otherwise 30 years is not allowed. Easy? Okay. Then next topic is starting. Okay, so this was the redemption rules. The penalty. है ना? Yes. चलो चलो चलो. Okay, here it is, issue and redemption of preference shares. Come on, bacha log. Do you remember the time period? Company can issue this for maximum 20 years, right? Can you see this? Cannot issue beyond 20 years. Can it go beyond 20 years also? Yes, but there were conditions. Then authority must be given in AOA. Yes or no? Then company cannot issue irredeemable preference shares, I told you. Correct? Then authority must be given in AOA. Okay. Then friends, you need to pass SR. We did this point. For issue of preference shares, special resolution is required to be passed. Then company must not have made any default and default must not subsist. Then redemption must be done out of what? Out of the profits of the company, okay, or out of the proceeds of fresh issue made for the purpose of redemption. Okay, which shares can be redeemed? Only fully paid up preference shares can be redeemed. Then this, when company is company wants to do redemption of preference shares out of the profits, then company is required to create what account? CRR account. Can you see all the points are same as our notes? Everything will get connected. First read that, then read this module. Okay, then at premium, if you are doing it at premium, then the premium amount can be payable out of securities premium account. Yes, out of securities premium account. Then next is see this point, see your point. Everyone, if company is not in the position to redeem preference shares, if company is not in the position to redeem preference shares, if company is not in the position to redeem any preference shares or to pay dividend, okay, so such shares in accordance with the terms of issue as per the promise, company cannot redeem it. Then what company can do? What you are asking me? Company may issue further redeemable preference shares equal to the amount due, okay, including the dividend amount, okay, in respect of unredeemed preference shares, and on issue of such redeemable preference shares, the unredeemed preference shares shall be deemed to have been redeemed. नहीं समझा? Okay, listen. And for that, what is required, वो मैं आपको बताता हूँ. ध्यान से सुनो everyone. Now, if company wants to redeem preference shares, redeem means company wants to repay your money and take the shares back. Clear? Now, company wants to repay how much amount redemption is for 10 lakh rupees, for example. So now company is not in the position to repay you the 10 lakh rupees or some dividend money also. So now what can company do? So for this redemption, company can issue new redeemable preference shares because there is a time limit for this one. So now company is issuing what? New redeemable preference shares to adjust this amount of redemption of preference shares. So can company do this? Yes, company can do this, but for that, company is required to obtain the consent of 3/4 in the value of such preference shares plus approval of NCLT. These two things are required to be complied, then company can do this. Sorry, this is not special resolution. In special resolution that is done in the general meeting, all members can come and vote. This is you need to take the consent of the 3/4 in value of that category of, that is class meeting. So who will come? Only preference shareholders will vote, and that is 3/4 in the value of such preference shares. It is not 3/4 in the number of preference shareholders. You understood now? So instead of making the payment, what company is doing? Company is issuing new redeemable preference shares. Okay, so done. Yes, that is maximum. Company is not in the position to repay the money, so your right is not getting affected. So company have this remedy. Company can do, but NCLT approval is required. Then only if 3/4 in the value of that category of investors, if agree, only then it is done. So there are conditions for that. It is not that a company is making default and company is doing this. There is a approval for that. Okay, and see this. The issue of further redeemable preference shares or redemption of preferences, we have already done from the book. This shall not deem to be reduction of share capital. Therefore, section number 66 is not applicable. Okay, clear everybody? Yes, then the resolution what you're going to pass for issue of preference shares. The resolution shall include what all things? The draft should include all these things. To whom you are issuing, for what payment, voting rights, everything. Then we told you for passing SR in general meeting you need to attach explanatory statement. Explanatory statement shall have all these details. Then their name shall be entered in ROM. Yes, the names of the preference shareholders are entered in ROM. Are you getting the point? Same to same. Then redemption must be as per issue terms only. If you want to change, then you need to comply with section 48. Okay, and here there is a procedure for that. Procedure means call meeting, pass SR, MJT 14, all these things. Okay, and one minute. If company is issuing preference shares, again pass 3 will come. What is pass 3? General principles of allotment. Whenever company makes any type of allotment, company have to file a return in form PAS 3. Any type of allotment. So here company is allotting what? Preference shares. So company have to file a return in form PAS 3 with ROC. Okay, that's same within 30 days with ROC. A return of allotment. Is this clear to everybody? Yes. Then. Okay. See this. This also we are going to do in a separate topic. When will company deliver the share certificate? Share certificate shall be delivered within a period of 2 months from the date of allotment. Okay. Done then. We are done with this topic. 55. Issue and redemption, both part is done. Yes, Tanish, that will be new redeemable preferences. Okay. Done from module. Okay. Can we go next? Tanish, clear? चलो भाई चले. Now what is next? 9:30 हो गया नहीं? पता नहीं चला नहीं? क्या बोलते हो? तेको पता चला? You always wait for break. चलो ठीक है, शुरू करें? नहीं, पढ़ाई शुरू करें. चलो, what is next topic? Share certificate. Now what is शेयर सर्टिफिकेट? बहुत मस्त इजी टॉपिक है, ध्यान से सुनो. देखो, अभी मॉडल में आगे पीछे होगा, ऑब्वियसली सीक्वेंस इज डिफरेंट, बट यस, शेयर सर्टिफिकेट. दिस इज नाइस वे टू स्टडी, नो? बताओ. सेम थिंग इज ओपन, बेस्ट. न्यू टेक्नोलॉजी नहीं, सेम फाइल, ग्रेट. what many students are doing, many students, जो उसको फेंक दे, उसका कोई फायदा नहीं है. Now, let's go ahead. Tanish, have you understood your doubt? I hope I have answered your doubt. Tanish, Tanish, नाराज है क्या Tanish? Tanish, reply करना Tanish. Tanish, please. चलो, next topic is share certificate. What is share certificate? See, very simple. Share certificate is issued when the shares were in physical form. In today's time, do you get share certificate? No, now it is in demat form. So today you just get statement of your transactions. Correct? So share certificate are issued when the shares are in the physical form to the members of company. In which form? In form SH1. In form SH1, first point. If your share certificate is lost or damaged, you can ask for duplicate share certificate, and board of directors may issue duplicate share certificate to you. Okay? Yes. Next, if company is issuing duplicate share certificate, company is required to maintain the records of that. Like company is issuing this type of certificate to whom? So if company is required to maintain register of renewed or duplicate share certificate in form SH2. SH1 is format of share certificate. SH1 is format of share certificate. SH2 is, this is your register which is maintained for details with regard to the people to whom duplicate said certificates were issued. Now point number 4. Tell me, is a share certificate official publication? Is this an official publication? No. It is not an official publication of Government of India, as it is issued by the company and not by the government. Understood? It is issued by the company and not by the government. Therefore, it is not official publication of Government of India. Okay. And yes, fifth point is, once you get the share certificate act as estoppel to title and estoppel to payment. What is this? Once you get the share certificate, now nobody can deny your title. Nobody can deny the ownership what you have on the shares. Therefore, estoppel is to title. Title means ownership. And estoppel is to payment. Now, nobody can deny that you have not made the payment. Nobody can say that you have not made the payment. You have share certificate means you have made the payment. So, estoppel is to title, estoppel is to payment. Easy? 6 points? Okay. Seventh point is, if company issues duplicate share certificate with the intent to defraud, if company issues duplicate share certificate with the intention to defraud the investor, so there is a penalty, right? Penalty on the company as well. That is okay. So total there are how many points? 7 points on this. Now see the 8th point. Just now we were doing that issue of preference shares. Then we spoke about issue of new preference shares, where company was not in the position to redeem the existing preference shares, right? So in that point, I told you that we will be doing this topic separately. Here it is. That is about time for issue of share certificate. Within how much time company have to issue the share certificate? Within how much time company have to issue? So see, what are the possibilities? Firstly, we will talk about subscribers to MOA. Do you know what is subscribers to MOA? These are the first members of company. So can I say, as the company is incorporated, these people became the first member of company, correct? So as soon as they became the first member of company, they became the member, they became the shareholder, so they should also get share certificate. So when will they get the share certificate? Within 2 months from the date of incorporation. Within 2 months from the date of incorporation, they get this. Everybody clear? Okay. What if it is a case of allotment of shares? Like we did allotment of preference shares. So if company is making the allotment, again the company will give you share certificate. Within how much time? Within a period of 2 months from the date of allotment. Okay. Then in case of debentures, you get debenture certificate. Yes or no? In debentures, you get debentures that company will issue within 6 months from the date of allotment. And in case of transfer or transmission of shares, within 1 month. I hope you know, only transfer is not enough. If I have certain number of shares, if I transfer those shares to you, so I'm transferring the shares. So now will you become the member of company? No. Only transfer is not enough. Transfer must be registered. Means I will have to apply to the company that please replace my name with this person's name, because now this person is the member. So we need to apply for registration of transfer. So as soon as you apply for registration of transfer, that is called instrument of transfer. That is called what? Instrument of transfer. Okay. So as soon as we make the application, as soon as we submit instrument of transfer, company will make the allotment of share certificate to the new one within 1 month. Within 1 month from the date of receipt of instrument of transfer. Clear everybody? Yes. Or intimation of transfer. What is this intimation of transfer? This is transmission case. See, one, it is a case of transfer of shares. Another is transmission of shares. Transfer of shares means I transfer my shares to you. Therefore now I will apply to the company. For what? Please remove my name from ROM and please add the name of this person. That is transfer. So whatever document I am applying, that document is called as instrument of transfer. But in case of transmission of shares, when do we talk about transmission of shares? That is by the operation of law. That is, for example, there is a member of company who died. Now the shares will be by operation of law transmitted to another person. If there is a nominee, then it shall be transferred to nominee. But if there is no nominee, then to the legal representative. That is by the operation of law. That is automatically. Correct. So that person can now go and tell company, that is company will receive what now? When this person, the legal representative, will go to the company and tell the company, now please this share should be in my name. Correct, as I am the legal representative of so and so deceased member. So this information is called as intimation of transfer. So from the day when you inform the company, within 1 month time, company will issue the share certificate. Is this clear to everyone? Yes, no. So this was the time limit for issue of share certificate, total 8 points. Okay, regarding share certificate. Yes. Next we have is personation of shareholder. What is this personation of shareholder? Okay, all the online students, are you listening? Yes, everyone on YouTube, everything is clear? चले तो फिर चलो let's go. So next topic is personation of shareholder. What is this personation of shareholder? Very simple. See, when a person intends to acquire the securities giving wrong identity, मतलब आप गलत नाम से शेयर्स अप्लाई कर रहे हो, खरीद रहे हो, राइट? यू इंटेंड टू बाय द शेयर सिक्योरिटीज गिविंग रॉन्ग आइडेंटिटी, or you intend to acquire the benefits by showing the wrong identity as the owner of securities. You are showing your identity as the wrong identity and you want to take the benefits of the shares which does not belong to you. This is called as personation. Such an act amounts to personation. Okay, easy. Obviously, what do you think? This act is what? Good or bad? Obviously, penalty shall be imposed. So there is a penalty under section 57, right? And 447. What is 447? Penalty of fraud. It's a very small topic. Okay. Yes. After this, next we have is what? Transfer of shares. Concentrate. Transfer of shares. Very simple. See, both the types of companies can issue shares, right? Private company also and public company also, right? Come on, we are talking about transfer of shares. So tell me, the shares of private company are transferable or not transferable? So obviously the private company share transfer is restricted but not prohibited. Correct? It is restricted but not prohibited. It depends on its AOA. If AOA allows the transfer, then it is transferable. Otherwise, it is not transferable. But when you talk about a public company, then it is freely transferable. Very basic. Now, the board of directors or any depository creates a restrictive condition on transfer of shares. For example, if the board of directors or depository creates any restrictive condition on transfer of shares. So as I told you, share transfer cannot be restricted anytime. Can you see this? No board of directors or depository shall have power to restrict, hold or refuse the transfer of shares. If they are creating any such restrictive conditions on transfer of shares, such condition shall be void. Easy? You understood this? So generally nobody can stop your right to transfer their shares. Okay? But there is one exception here. What is this exception? In case where there is a contract between two or more persons with regard to transfer of shares shall be valid if any arrangement or contract between two parties, okay, or shareholders of a public company create restriction upon the right to transfer the shares, such restriction is valid. नहीं समझा? चलो example. Therefore I wrote the example clearly. Suppose for example, I am a founder of a company. Now I am running that company for a certain period of time and now I want to raise funds. No, I want to sell my company. Okay, and I want to raise funds. So what I did, I am offering you certain percentage of my company shares. Let's say for example, I'm offering you 40% equity and I want so and so amount. So what if I did, I raised my capital from you and I allotted you the shares, issued the shares 40%. Same way I did the same with other parties also, 20%, 10%. Now you know why you people invested in my company, because you trust me that I am running a good business and I will take the company to next level. Therefore you put your money in my company, right? But what I did, what if afterwards, once I get the money, what if I leave the company, I sell all my shares and I just go away? So will your money go down? Yes. So therefore what you people can do is, you people, while giving me the money, there can be a contract between you and me. You and me means you are investor, I am promoter. So there can be a contract between two persons. You can put a condition like, you will not transfer your shares for so and so years. Only then we are ready to. So there is a contract between these two parties. So due to this contract, we are putting a restrictive condition. You are not allowing me to transfer my shares. So this is a restriction, but this restriction is valid. This restriction is valid. That is, the same thing is given here. So you can set up a lock-in period in the contract. Okay, everybody understood what I told just now? So this is about this restriction, transfer of shares. It depends on the contract. Now see these two things. Shares can be in the physical form, shares can be in the electronic form. Okay, if the shares are in the physical form, the transfer of shares shall be effected by the company through registration of transfer. I told you only transfer is not enough. Transfer must be registered because shares are in the physical form. Means here name will be entered in the ROM. Yes or no? So in such case, what you need to do is you need to record the details of transferee in ROM in place of transferor. Means the name of the party shall be changed. This is when the shares are in the physical form. Okay? But when the shares are in the electronic form, how will you transfer the shares? Just by the click of the button. That means here the transfer of shares shall be effected through depository. This is possible through depository. Very simple. Easy. So how transfer of shares shall be effected when the shares are in physical form or electronic form? Okay? Yes. Now see through this part. You know right now which topic is going on? Transfer and transmission of shares. Okay? Come on. What is next? Please concentrate and understand this diagram. See, suppose chalo. Now see, this is Mr. A, Mr. A and Mr. B. Okay? Now Mr. A was having some shares. What he did? He transferred his shares. He transferred his shares to Mr. B. He transferred his shares to Mr. B. Okay? Now tell me, earlier Mr. A was a shareholder of Tata Motors. The company you can see here, Tata Motors Limited. So when Mr. A was the member of company that time, can I say Mr. A's name was mentioned in the ROM? Yes. Mr. A's details were entered in the ROM of company? Yes. Now what do you think? Mr. A has transferred his shares? Yes. So once he transferred his shares, is that enough? Only transfer is not enough. Transfer must be registered. Means you can see still Mr. A is having his name in ROM. So we need to change the name in the ROM. Means this is called as what? This is called as registration of transfer. So what Mr. A is required to do now? Mr. A is going to apply to the company. He will apply to the company for registration of transfer. Mr. A will apply to the company that please remove my name and please add the name of transferee. That is Mr. B. Everybody understood? Yes, no? Fine. So now what Mr. A did? Mr. A applied for registration of transfer in which form? In form SH4. Okay? Yes, stamp duty, duly signed stamp, everything in the given format. This is called as instrument of transfer. I told you earlier also. When you apply for registration of transfer, it is called as what? Instrument of transfer. I hope you remember this. You know the topic which we had a time limit to issue the share certificate. So that time we told, as soon as we give instrument of transfer, company allots the shares, a share certificate within 2 months from the day of receipt of this instrument of transfer, right? Fine. Chalo. So this Mr. A has applied for registration of transfer to the company. First point. Okay. Now what will company do? Company will check the documents. If everything is proper, company will issue that share certificate within 2 months. So this is your basically your first point. Okay. Now friends, if suppose, okay, 1 minute. Yes, Mr. A can make this application. Okay. Who is Mr. A? Transferor. But what if this is a case of intimation of transmission? Do you understand intimation of transmission? That is, the transferee will apply to the company. Can transferee apply to the company? Yes, transferee can also apply for what? Apply for registration of transfer. So he can apply. While applying for registration of transfer, transferee will submit what? Letter of allotment. Letter of allotment. I have the letter of allotment. I have the proof. Please transfer the shares in my name. Understood? So application can be made by transferor also and transferee also. Easy? Okay. And in both the cases, company will allot the share certificate, issue the share certificate within 2 months. Now see the blue thing. Okay, see the points. First, if the shares which are proposed to be transferred are partly paid up shares. Do you understand partly paid up shares? Means there is some unpaid amount on shares. And now Mr. A has applied to the company, please transfer the shares, please register this transfer in the favor of Mr. B. Okay, and the application for registration of transfer is made by transferor alone. Understand one thing, Mr. A is having what type of shares? Partly paid up shares. And he is making application for registration of transfer. Who is making the application? Transferor alone. Now what if company register this transfer? What if company register this transfer in the name of Mr. B? Then what will happen? Friends, now the liability will be on Mr. B. Liability of unpaid money because shares are partly paid. Yes or no? So what will company do in this case? So whenever company receives a request for registration of transfer, request from transferor and the shares are partly paid, so company will not directly register the transfer. What will company do? Friends, this was first point. Company will send a notice in form SH5 to transferee. Company will send a notice in form SH5 to transferee, that is Mr. B. Why? Yes, to check his objection. Okay, now point number 3. Transferee shall give his NOC within a period of 2 weeks from the date of receipt of SH5. He will give the NOC. Yes, I have no problem. Please transfer, register the transfer in my name. I am okay with partly paid up shares. He will give the NOC and then company shall register the transfer. Everyone, are you clear how it goes? Yes? Yes. And then if the shares are in electronic form, if the shares are in electronic form, then no transfer deed is required when the shares are in the electronic form. You know, that is done with the help of depository. In that case, all this process is not required because when the shares are in the electronic form, our name is not anyway, it is not there in ROM. Understood everybody? Sure? Yes. It's all done. If it is lost, then board of director may register the transfer on the terms. See, that is what I told you, this transferee have to submit what? Letter of allotment. This in the first case. Letter of allotment, right? But what if that is lost and transferee goes to the company and says that please register the transfer in my name, I don't have letter of allotment, please, it is lost. So in that case, will board of director register the transfer, allow this? So board of director may register the transfer, okay, on such terms decided by the board by obtaining indemnity. What is this? Means board of director will make this person sign the indemnity rule. Means we are transferring as per whatever you are saying. But if in future we come to know that whatever you were saying was not right, you have no right on these shares. If in future we come to know about this, then you will be liable to indemnify for the losses. Okay, so they will get that indemnity rule signed by the transferee. Everybody understood what I'm saying? Okay, this was about that. Now see this. This is intimation of transmission. What is intimation of transmission? This is transmission of shares. We were talking about transfer of shares till now. Now this is transmission of shares. When do we talk about transmission of shares? Whenever the member of company dies, the shares are transmitted to the legal heir. Yes or no? Yes. So see this. the original holder of shares died. The member of company died. Okay. Now shares will be transmitted to his legal representative. So tell me, is she going to submit instrument of transfer? No. She is going to submit to the company what? Intimation of transmission. That the shareholder died, your member of company died, I am his wife. I am legal representative, so kindly register the shares in my name. Such intimation she will give to the company. Understood? Okay, she have to submit this within how much time from the day of death? So there is no time limit for this. She can show up anytime. Okay, so she will submit this to the company. So friends, we have done two things. In the previous this example, we were talking about instrument of transfer, and here we are talking about intimation of transmission. So two things: instrument of transfer, intimation of transfer. This is in case of transfer of shares, this is in case of transmission of shares. Yes or no? Yes. Now friends, both the requests were made to the company. Both the requests were made to the company. Now what will company do? Come on, both the sides requests were made for what? For registration of transfer or transmission. Now what will company do? Friends, company will register the transfer or transmission within a period of 30 days of receipt of instrument of transfer or intimation of transfer. Come on, once you make the application to the company here, once you make the application to the company, once you send the instrument of transfer, company will register within, yes, within 30 days. And this is for both the cases, instrument of transfer as well as intimation of transmission. Everybody understood this? Yes, no? Okay. So within 30 days. Or company may provide reason for refusal to register the transfer or transmission. So company will either register the transfer within 30 days, or company may give the reason for refusal. Is this clear to everybody? Within 30 days. So 30 days is common. Within 30 days, either register, either provide the reason for refusal. Okay. Now what if you have given intimation of transmission or instrument of transfer to the company for registration of transfer? Now what if company has refused to register within 30 days? Company gave you the reason for refusal to register the transfer. Now what you can do? You have remedy for that also. Now what remedy you have? You are not happy with that refusal, so what you can do now? So firstly, if it is a case of private company, okay, then what will happen? And if it is a case of public company, then what will happen? Okay, first we are talking about private company. See, there were two possibilities. First, company may give you the reason, or company may not give you the reason. Okay, so if the notice of refusal was given by the company to the applicant, come on, what is the first one? If the notice of refusal notice was sent from the company to you. So if company has sent you that notice, now what you can do? Refusal notice company has given you, now what you can do? The applicant may make an appeal to NCLT within 30 days from the receipt of that refusal notice. You understood that? Firstly, tell me, company will send you the refusal notice within how much time? 30 days. Correct? Within 30 days. And the day when you receive the refusal notice, you can appeal within 30 days from the day when you have received it. This is the case where company has sent you the refusal notice. What if company has not given you the refusal notice? No refusal notice is given to you. So here what has happened? Here nothing. You have just applied. You have just submitted what? instrument of transfer. Instrument of transfer or intimation of transmission. You have submitted that, but company has not replied anything within 30 days. No reasons for refusal is given. Now what to do? So you are not happy. You want to appeal. So in such case also you can appeal to NCLT within 60 days from the day when you have submitted instrument of transfer or intimation of transfer to the company. Do you know the logic of the 60 days? See, when you apply to the company for registration, the previous slide we did, when you apply, so company will either register within 30 days or provide you the reason within 30 days. So once you apply, company has not given you any reason. So now you want to appeal within 60 days, 60 days from the day when you have applied. Because company has not given you the reason, no. If company has sent you the notice, in the previous case you saw, company has sent you the notice, then we can appeal within 30 days. 30 days from the receipt of that notice. But in this case you saw company has not given you the reason, therefore 60 days. You can appeal within 60 days. Why 60 days? Because 30 days anyways you need to wait for reply or registration. Okay, so you wait for those 30 days and then further 30 days you get time for appeal. So total 60 days. So this was in case of private company. In case of public company, again same. Come on, if company has given you the notice of refusal to the applicant, so what to do? So applicant refusal, company gave the reason of refusal. So now applicant can appeal within 60 days from the receipt of notice. Okay, applicant can appeal within 60 days. But if company has not given you the notice, then what to do? So you can appeal within 90 days. Why 90 days here? Because company has not replied to you the notice. So basic, when you make the application for instrument of transfer, intimation of transfer, first you need to wait for 30 days. That company will either reply or company will register the transfer. So wait for 30 days for that. And for appeal, what is the time limit you get in public company? In public company, you get time limit to appeal is 60 days. So 30 here they have not given you the reply. So 30 plus 60 days appeal, total is 90 days. Easy? Yes. In private company, you are getting time of 30 days for appeal. In public company, you are getting time of 60 days for appeal. Everyone is clear? Then here again very small topic, transmission of shares. You know what is transmission of shares? It is by operation of law, automatically by law. Okay, that is in case of death, insolvency and so on. Okay, so it is not by the act of party, means no one is transferring shares. It is done by the operation of law, that is automatically by law. No stamp duty is payable in case of transmission of shares. Okay, it is not, in all these cases stamp duty is not required to be paid. You know when the stamp duty is paid? When the ownership is transferred. But here there is no such thing for transmission of shares. In all these cases stamp duty is not required to be paid. Okay, now tell me, in transmission of shares, do you need to submit instrument of transfer? You need to send intimation of transfer. So no instrument of transfer is required in transmission, but intimation of transfer shall be sent to the company by the for registration of transmission, just to add the name of legal representative in ROM. Everybody understood this? Simple. Okay, what is next topic? This and this. Yes, still here we will do, then we will go for break. Okay, so that we can finish the transfer and transmission of shares completely. Come on. Now we are talking about forged transfer. You know what is forged transfer? Fake transfer. Come on. Yes. Forged transfer. What is forged transfer? Fake transfer. The forged application was made. Forged application was made for registration of transfer. Where the application was made? To the company. Concentrate. The instrument of transfer presented to the company for registration of transfer may be forged, may be fake. Fake application was made. Can you get this point? Fake application was made for registration of transfer. Now, what will company do? Will company register the transfer or company will not register the transfer? So firstly, whenever company will get this application, okay, company therefore confirms with the transferor about the receipt of instrument of transfer. Let's say for example, if the transferee is making application to the company and that application is forged request, that instrument of transfer is forged, that application is forged. Okay, so now for example, shares belongs to me and you are making application to the company that kindly transfer the shares in my name. You are making that type of request to the company. Okay, so whatever request you have made, whatever instrument of transfer you have submitted, that is completely forged. So therefore, if transferee is going to make an application to the company, what will company do first? Company will first ask the transferor that we have received this request, are you okay with it? Understood? So here it is, please concentrate. So within, okay, transferor may get opportunity to raise the objection. So as it is forged, so transferor may say that, don't transfer it, no, it is forged, I am not willing to transfer the shares to this person. Okay, so transferor may have objection, but company will ask the transferor. But if transferor does not raise objection, then company will register the transfer. If objection is not raised within the specified time, then company will register the transfer. So now what has happened here? Here company has registered forged transfer. Now what is the impact of this? What is the impact of this forged transfer? Let's see. Can you see these consequences of forced transfer? What are the consequences? First, such transfer shall be null and void. Remember one thing always. Such transfer shall be null and void. What is null and void? Such transfer shall never be valid. Okay. Second, the original owner continue to be the owner of the shares. The original owner will continue to be the shareholder of the company and company shall restore his name in ROM. Company will add back his name in the ROM. Third, forced transfer can never transfer ownership from one person to another. Means the transferee who has made that application will not get the ownership. Okay, next, if company register the forced transfer, the true owner can apply to the company for restoration of name in the ROM, as I told you. Okay, but see this point. If company register the forced transfer and issued a share certificate also, who is having share certificate right now? Transferee is having the share certificate. Now what that transferee who had make a forged application, okay, now what that transferee did, transferee sold such shares to the third party, to the innocent buyers. Okay, to the innocent buyers. Now company came to know it was a forced transfer. Now tell me that innocent buyers, the third party, will get the ownership or not? The buyer, the new buyer, the innocent buyer will get the ownership or not? So here we are saying that company is liable to compensate the innocent buyers. Because what we told, the real owner continue to be the owner. Yes or no? Here what we told, forced transfer will never transfer ownership. Therefore, who is the owner here? The real owner is transferor only. So what about the new buyers? New buyers' right is getting affected. Who will compensate to the new buyers? Company will compensate to the new buyers. But sir, this is wrong. Why company should compensate? Right? company didn't do anything wrong. The mistake actually was done by transferee. Catch the transferee. Therefore, there is one more point. Sixth point. It says that company is liable to compensate the new innocent buyers, third party, and company shall initiate legal action on the transferee who made the forged application. Okay, so company will recover the damage from the person who made the forged application. Is this clear to everybody? It says that ownership transfer is not valid only. Forced transfer will not give, will not transfer the ownership from one person to another. So the ownership which is there with the innocent buyers is not a valid title. Therefore, company will compensate to them because they will sue the company. We are the shareholder of the company. So therefore, now we will say company is in loss. Therefore, company have rights to recover it from the transferee. Okay. Yes. What is next? Next is transposition of shares. What is transposition of shares? See, transposition of shares is very simple thing. Transposition of shares is what? Transposition of shares means it refers to the change in the sequence of the name of shareholders in case of joint shareholding. Like there are two shareholders, Meet and Jeet. They both are the shareholders, joint shareholders. They both are holding some shares of a particular company. So whose name is first? Meet's name is first. So what do you mean by transposition? We are going to change the sequence of the name in the joint shareholdings. We are going to change the sequence. You understand sequence? Now Jeet will be in the first name and my name will be in the second name, right? That is called transposition of shares. Okay. For transposition, request shall be made by both the joint holders. Okay, but here no rights are transferred, no interest is created or interest is transferred, no stamp duty is required to be paid because it is just the change in the sequence of name, nothing else. No other rights are getting affected. Both are still the member only. Okay. Yes, now the last topic related to transfer and transmission of shares. Okay, let's go. Now, see what is this. Company has received a request to register the transfer. Company has received an application for registration of transfer. Okay, company has received this request, but company has not yet registered the transfer. Company has not yet registered the transfer. Okay, now what happened? Before company registered the transfer, company came to know. See, there was a death of transferor. There was a death of transferor. Means the person who applied, that is transferor, he died. Before the transfer was registered, the transferor died. Now what happened? Before the transfer was registered, the transferor died and company is having no notice of his death. Company is not aware about his death. So what will company do? Company has received a request, application to register the transfer. So what will company do? Company will register the transfer in the name of transferee. Can you see this? Company shall register the transfer in the name of transferee. Easy. That is our second point. First point is clear, दोस्त. बस अभी उस पे आते हैं. Come on. Now, next point is Company has received the application for registration of transfer. Before the transfer was registered, transferor died, but company is having notice of his death. Company is having notice of his death. Company has received the application from transferor, and now he is aware about the death also. Company is having notice of the death. Now what to do? Will company register the transfer? Company shall not register the transfer in the name of transferee until the same is referred to the legal representative of transferor. Means here company is going to reconfirm with the legal representative of transferor. Easy. Now what if the same case transferee dies before the transfer is registered? Transferee dies. Transferee means the beneficiary, person who is going to get the shares. If that party dies before the transfer is registered, then what to do? So again there can be two cases. First, company is having no notice of his death. Company is not having notice of his death. Understand one thing. Transferor has applied for registration of transfer. Who died? Transferee died. Is company aware about this? No. What will company do? Company will register the transfer. Right? So company would register the transfer in the name of transferee. But what if company is not having knowledge of the death? Sorry, if having knowledge of the death. If not having knowledge, company will register. But if company is having knowledge of the death of transferee, then now company is very much aware. The person to whom the shares are to be transferred died. So now what will company do? Company will register the transfer in the name of legal representative of transferee with the consent of transferor. First company will ask the transferor, transferor, you told me to register in the name of that party, now he party died. Should I transfer? Give your consent. If he gives the consent, then it will be registered in the name of legal representative of the transferee. Clear? Everybody understood transfer and transmission of shares? Yes. If he gives the consent, it will be done, otherwise no. Yes, online students, clear this much. Share capital chapter is easy. This was share and share. This was transfer and transmission of shares. Whatever we did till now, all these topics related to transfer and transmission of shares. Are you all clear? This much? Sure? Okay. So after break, we will start with private placement. Okay. Okay. Chalo. See you after a small break. Now, what is next topic? Let's continue. So next topic is private placement. Come on everybody, let's start फटाफट. ये थोड़ा चालू कर दो. चलो. Now friends, एक होता है public issue. आपको पता है what is public issue? Shares which are offered to general public. General offer is made, correct? But एक होता है public issue, दूसरा क्या होता है उसका opposite? Private placement. Public issue में doors are open for everybody. Anybody can come and subscribe the shares. But in private placement, how can, see, public issue can be done only by the public listed companies. So what about the other companies? Other companies can also raise capital. Yes, other companies can raise capital by the way of private placement. So as you know, public issue means offer is made to the general public, doors are open for everybody. But here, what is private placement? See, follow the points and your topic will be done. Here, this is an offer given to a specific group of persons. This is an offer given to the specific group of persons. This is not offer which is open for all. Okay, offer made to a specific group of person to subscribe the shares. Not for all, but for a specific group of people. So is this a general offer? No, it is a specific offer. Okay, and this is other than public issue. This is other than public issue. Come on, first point over. Very simple. Second point. Now, when you are making this type of offer, this can be made to maximum 200 persons. Maximum 200 person, and when you calculate the number of people, you need to exclude QIBs, that is qualified institutional buyers, and the employees of the company to whom the shares are given in ESOPs. Excluding these two categories, maximum number of persons allowed is 200. Okay, not more than that. Second point. Third point, when we are talking about this limit of 200 persons, separate limit shall be treated for each kind of securities. You understood? Means 200 for each kind of securities. So 200 number of people is not aggregate. 200 preferences, 200 equity, that way. Each kind of securities, number of limit is 200 persons. Offer can be made to specific group of people, maximum 200. Okay, now point number 4. This is an offer given to a group of persons. Who shall be those people? Who will identify such people? Board of directors. Okay, means offer shall be given to the persons who are selected by the board of directors, who are determined by the board of directors. Easy? Fourth point. Now fifth point. How to give them this offer? To subscribe the shares, are we going to issue prospectus? No. This is letter of offer is sent to such identified person within 30 days from the date of recording name of such identified persons. You understood this? The day when these people are identified by the board, within 30 days you need to send the letter of offer to such identified people. Okay, you can send this in writing or by electronic means. Sixth point. No person other than identified person can accept the offer. Offer is made to a specific group of people. Only those people can accept the offer, no one else. Okay. And here, suppose if the offer is given to you, you are one of the identified persons, offer is made to you. Can you renounce this right? Can you renounce this offer? So no right of renouncement. What is renouncement? Means you cannot transfer this to anyone else. Okay, so in private placement you don't have such right. Okay, no right of renouncement. Then for this kind of offer, as you know, it is a private placement, offer is made to a specific group of people. Therefore, for this kind of offer, no public advertisement should be done. No utilization of any media, no marketing, no distribution channel, no announcement to public. All these things should be avoided. Okay, and once company is raising this money, company shall not utilize the money raised by private placement unless allotment is done and return of allotment is filed with ROC in form PAS 3. You know this very well. PAS 3 return of allotment is to be filed with ROC. So company cannot utilize the money unless it is allotment is done and return is filed with ROC. Okay. Then if non-compliance is done, then there will be penalty on the officer in default. 9 points. 10th point. Such people can invest money, can subscribe such shares by paying the amount in check, DD, but not cash. Cash is not allowed. Check is allowed. DD is also allowed. Are you getting the point? 10 points. Now 11th point. No fresh offer can be given by the company unless allotment with regard to offer which has been given earlier was completed. Now suppose if company has already made this type of offer earlier, and now company is making one more offer of private placement. So if the earlier allotment is pending, you cannot make a fresh offer now. Unless the allotment with regard to earlier offer is pending, you cannot go for fresh allotment, fresh offer. Okay. Then company shall allot more than one securities to the identified persons subject to the maximum limit given under section 42. What is this? See, we told you there is a maximum limit of 200, but 200 is in each kind of securities. So suppose company is offering me, let's say I have subscribed the debentures also by the way of private placement, and I have also subscribed the shares. So can the, say, one person can have more than one type of securities? Yes. Subject to maximum 200 limit, that's it. Understood? Means I can be counted in the maximum limit of 200 in shares also, and same person can be counted in the maximum limit of 200 for debentures also. A person can have more than one kind of securities under private placement. Okay. Now next is company shall make allotment within 60 days. That general principles of allotment. Okay, from the date of receipt of application money. If not allotted in 60 days, company have to refund the application money in next 15 days. Easy. And if fail to refund, there is a interest payment. No. Deposits. सी ये सब कैसे होता है ना, पहले इसको साइड में रखा जाता है. आपको याद है आईएफएससी की बात कर रहे हो, शेयर एप्लीकेशन मैंने रिफंड नहीं किया 15 दिन में तो डिपॉजिट्स. करेक्ट. हाँ. एंड ये तो पेनल्टी है. दिस इज कंपनी विल हैव टू रिफंड द मनी विद इंटरेस्ट नाउ. ठीक है. Okay, the share application money, company shall keep this money in a separate account called as escrow account, because company has just received the application money. Company will keep this in a separate account and not be utilized for any purpose other than allotment or refund. So company has received the share application money, so company will either allot the shares against this money received or refund this money. Okay, 12 points are over. 13 point is, if money is raised in contravention of section 42, so there is a penalty in officer in default. And if you go for private placement to the persons more than specified in the limit, that is more than 200 persons, if you make the allotment for more than 200 persons, then this shall be treated as a public offer. This shall be treated as a public offer. So sir, now it is good. If it is treated as public offer, then nice. Now we can make offer, we can raise capital from n number of people. No, you will be in problem. See, you are not eligible for public issue, therefore you are going for private placement. And now you are making offer to more than 200 people, therefore it will be treated as a public issue. So if it's a public issue, you should be eligible for public issue. If you are not eligible, that means there are penalties. So non-compliance. Understood? So therefore it's written here, it shall be deemed to be a public offer, and all the provisions of SEBI Act, SCRA Act, Companies Act with regard to public offer shall be applicable. See, all the rules of public offer shall be applicable on you then. But you are not eligible. So all the public offer rules you have not complied. So there will be penalties from all the sides. So you will be in problem. Okay, so how many points for private placement? 14 points. Are we revising one more time? Yes. All the points together. Once again, please concentrate. First, come on, private placement. Offer is given to a specific group of person to subscribe the securities. This is other than public issue. First point is done. Second point, to how many people offer can be made? Maximum 200. 200 is in each kind of securities. Okay, this 200 limit will exclude QIBs and the shares allotted to the employees under ESOPs. Correct. Point number 3 is done. Point number 4, offer is given to a specific group of people. Who will determine those people? Board of directors. Once the board of directors have identified the number of persons, now we will send them what? Letter of offer within 30 days from the day their name is identified by the board. Okay, then point number 6, here no person other than the identified person can accept the offer. Offer can be accepted by the identified person only, and here such people don't have right to renounce the right. Okay, then next is point number 7. No public advertisements, no public announcements, no marketing for raising this kind of money because it is a private placement. Okay. Okay, next is point number 8. Company cannot utilize the money which is raised by the way of private placement unless the allotment is done and return of allotment is filed with ROC, pass 3. Okay, then point number 9, if non-compliance there is a penalty. Point number 10, such person can invest in the company by the way of private placement. By which mode of payment? By DD, check, but not by cash. Point number 11, no fresh offer can be given by the company unless company has completed the allotment of the offer made earlier. Okay. Okay, next, company can allot more than one type of security to such identified person subject to maximum 200. Means one person can hold more than one type of securities under private placement. Then company have to make the allotment within 60 days. If not allotted within 60 days, company have to refund in next 15 days. Easy. If made default, company have to pay interest. Then if money is raised in contravention of section 42, there is a penalty. And if company has made a private placement issue to more than 200 persons, it shall be treated as a public offer, and all the provisions of public offer shall be applicable on such company. Easy. Private placement is over. You know what? Whatever is there in your module is covered. After reading this, you should read your module. It's done. So point था सारा 14. Chalo friends, what is next? Next is section number 63, issue of bonus shares. Online, everyone ready? Clear? Yes. Now issue of bonus shares. Tell me what are the bonus shares? Okay, chalo. Now, concentrate please. Issue of bonus shares. Yes. Firstly, bonus shares means what? Company is issuing shares at discount. Company is giving shares free of cost. To whom? To existing shareholders. Correct? So this is a kind of a benefit given to the existing shareholders. So what compliance requirement is there for this type of issue? First, authority shall be given in AOA. AOA should allow you for such an issue. Second, if authority is not given in AOA, then what to do? Alter AOA by passing SR. Easy? Everybody keep this in mind. Simple. Okay. Who is going to recommend this issue? Board of directors. You know, same like dividend. Who recommends the amount of dividend to be declared? Board. Same here also, board. Okay, issued on the recommendation of board of directors. Easy, everybody? Now, if company wants to issue bonus shares, what type of resolutions company is required to pass? Ordinary resolution. Do you remember something? Past 3 general principles of allotment. In that, there was one point in general principles of allotment in my notes that if company is issuing bonus shares, when you file pass 3 with ROC, you need to attach copy of OR. Do you remember that? You don't remember that? See this. In general principles of allotment, notes are so colorful, right? कोई बात नहीं, कलर है ना, बस ठीक है, आपको जैसा लगे वैसा कर दो. See this, pass 3 allotment rules. Can you see this point? We were talking about what company requires to attach along with pass 3. So there were different rules. See this point. If company issues bonus shares, copy of OR passed in general meeting need to be filed with pass 3. Okay. So for bonus shares, company requires to pass ordinary resolution. But first, authority must be given in AOA. If AOA is not allowing, then pass SR for altering AOA. And then pass OR for this issue. Once the bonus shares are announced by the company, cannot be withdrawn by the board. Okay, that is as per company share capital and debenture rules 2014, rule number 14. Okay, once announced, cannot be revoked. Very simple. So this becomes your third point, that is passing ordinary resolution. Now, can I say bonus shares means it is something given free of cost? Shareholders will be happy. You know, dividend is also something this only. Dividend is also something given out of free of cost to the shareholders. So can company give bonus shares instead of dividend? Can company give dividend instead of bonus shares? Answer is no. We have done this in chapter in class. When we were doing dividend chapter, I told you, can company issue bonus shares instead of dividend? Answer is no. Why no? Huh? Answer me one thing. 1 minute. Is company, is it compulsory for company to give dividend? Is it compulsory for company to give dividend? Is it liability for the company to give dividend? Or what if company has made profits? Then is it compulsory for company to give dividend? Company has made profits. Company has made profits. Pakka na? Then why you gave that type of answer? That is about rights related to voting. We are talking about the liability of company. Correct? So yes, so in the dividend chapter we did that issue of bonus shares and declaration of dividend, these are two different corporate actions. Therefore, company cannot declare dividend instead of bonus shares and bonus shares instead of dividend. There are different rules also for that. Correct? Fine. So that becomes your point number 4. Cannot be issued instead of dividend as these are both different corporate actions. Okay? Fine. Now tell me, if company is giving bonus shares. I asked you this question when we were doing that part also. General principles of allotment also. If company is issuing bonus shares, the number of shares will increase, share capital will increase. So company will have to transfer the amount, the value of the shares into share capital account. So from where will company take out the money? Do you remember? Out of securities premium account. We did that issue of shares at premium, the first topic. In that we did utilization of securities premium money. In that first was fully paid up bonus shares. So you can issue bonus shares out of securities premium account, CRR account, and out of free reserves. Okay? And bonus shares shall be given only on fully paid up shares. Easy? This becomes your point number 5. Okay? Now point number 6. If company wants to announce bonus shares, company must not have made default in the repayment of any amount, principal amount, interest amount on any debt instruments and statutory dues of employees. You understand statutory dues of employees? Whatever the rights of employees are there, you have paid all the money on time, like gratuity, other statutory duties of, yes, all other benefits. So company should not have made default basically. Okay, so this is your issue of bonus shares, 6 points. Come on, can we revise this once again? All the points together one last time. Chalo. First, authority must be given in AOA. If authority is not given in AOA, we will alter AOA. We will alter AOA by passing SR. Okay. Third point. Companies need to pass ordinary resolution for approving the issue of bonus shares. Then point number 4. Company cannot issue bonus shares instead of dividend. Cannot give dividend instead of bonus shares, as these are two different corporate activities. Company can issue bonus shares out of what money? CRR, securities premium, and free reserves. Perfect. Then sixth one. Yes, it can be given only on the fully paid up shares. Then for making such issue, company must not have made any default in the repayment of principal money or its interest or statutory dues of the employees. 6 points over, topic over. Yeah, that is already done in the general principles of allotment. You need to attach the copy of OR with pass 3. So you understood those were the general principles of allotment. But wherever we are talking about the issue, allotment, always you need to follow those rules, general principles. Easy. See, I hope you know now how to use these notes. Also, you should do one more thing. Like today is a revision class. Otherwise, what I do in class, one section is over. You read this section now from your module. Yes. Okay. ये पूरा मैच हो जाएगा. So read the same thing. This is in the diagram form. But obviously in exam we can't make diagrams. You need to frame your sentences in points. So read this and then read the same section from your module. Then it will be very much ready. Concrete ho jayega. Okay, fine. Chalo, what's next? Next is equity shares with DVR. That is differential voting rights. I told you one is pari-passu rights. Another is differential voting rights. Okay, so now here also there are points, very simple. You can see total 10 points and it's over. Okay, first, equity shares with differential voting rights. This is allowed only if authorized in AOA. If AOA is not giving authority, we need to alter AOA by passing SR. Okay, this becomes your first point. Second point, if company wants to issue equity with the DVR, company need to pass ordinary resolution in general meeting. Only then this is allowed. So second point is also done. Third point, in case of listed companies, company can pass OR by postal ballot, voting by post. Easy? Okay, third point. Yeah, that depends on the rules of, that is AOA of the company. Now, how much equity with the DVR company can issue? So it is 74%. Yes or no? 74%. Yes or no? Yes. Okay. Here what you can see? Maximum issue of equity shares with the DVR company can have is what? 26% of the post issue paid up equity share capital, including equity shares with DVR. That is one and the same. 100 minus 26 is understood. Everybody. So this is the maximum limit what company can issue. Okay, and there in your book you can see that 74 what is written there, that is talking about voting rights. That line will talk about voting rights. Okay, so this is the maximum limit what company can issue, that is equity with the DVR. Now the company which intends to issue this type of equity shares, equity with the DVR, must have track record of dividend for 3 consecutive years in the preceding years, the preceding 3 consecutive years. Only then company is allowed to do this type of issue. Okay, then company must not have made default in any of the following. That is, company must not have made default in filing financial statements, annual returns in the 3 preceding financial years. Company must not have made default in the payment of dividend. Company must not have made default in the repayment of matured deposits. Right? Redemption of preference shares, redemption of debentures, default नहीं होना चाहिए. Payment of dividend on preference shares, repayment of term loan from scheduled bank, public financial institution, state level financial institution. Basically none of the default should have been made. Okay, but company may issue equity with the DVR upon expiry of 5 years from the end of financial year in which such default was made good. Means company must not have made any of the defaults. Like for example, if company had made this type of default and now the default is made good and 5 years has been lapsed from the end of financial year in which the default was made good, then company can issue equity with the DVR. Means can I say default is made good and you have to wait for 5 years, before expiry of 5 years company cannot issue equity with the DVR. Okay. Then company has not been penalized by any court or NCLT for any offense in 3 preceding financial year with regard to FEMA, SCRA, RBI, other by which company is governed. So no penalty has been imposed on such company. Okay, then when you are passing which resolution for this type of issue? Ordained resolution in general meeting, right? So now that is a chapter in CMSL, SCRA, Securities Contract Regulation Act. So when you are passing OR, you need to attach explanatory statement along with the notice of general meeting, giving all the details to the members so that they will read that and they will ready with their votes. Okay, now tell me, the holder of equity shares with DVR are entitled for all the corporate benefits just like other shareholders? Yes, they are entitled for all the corporate benefits such as bonus shares, dividend, rights, everything. Okay, then you know there are 2 types of equity shares, paripasu and DVR. So company cannot convert equity with paripasu into DVR and equity with DVR into paripasu. This equity shares cannot be converted, not allowed. Okay, and whatever amount of quantity of equity with DVR is issued by the company have to give the disclosure in the board report forming the part of annual report. I hope you know what is annual report, board report. Every detail is given in it. Whatever activity company has done throughout the year is disclosed in the board report. Okay, yes. Now what is next? Next is your further issue of capital. You know what is further issue of capital? See this, we were going with the module. This is the procedure and then here it is. Can you see further issue of capital? Section number 62. In this you are going to study 3 things. One is right issue, then ESOPs and preferential basis allotment, preferential allotment. Okay, 3 things you are going to understand in this. Ready? Can we start one by one? So first we are going to do the first one, that is right issue. Right issue of shares. In your module, can you see this right issue? The first one is right issue. Let's go. Kamna, I'm not getting a doubt. What you're saying, difference between BR and AR. What is AR? अरे बाप रे. Okay, okay. Who made this abbreviation? See, Kamna, board report is a part of annual report only, and I hope you have studied the chapter annual returns. See, board report has a specific disclosures. Specific disclosures are a part of board report, and annual report has other disclosures. So basically, annual report is a document which contains every activity done by the company, like whatever chapters you have studied in company law, like for example CSR. So CSR, in that CSR, where the activity was done, CSR activity, how much amount was spent, then directors we did. So which additional director was appointed in the financial year, which director was removed, which director was resigned, which this company has raised money by issue of debentures, how much money was raised, which new products were launched, has company imported any technology, new technology from outside India, date of import. If company has declared dividend, what was the amount of dividend declared, from where the money was arranged, everything, whatever activity, whatever law you are studying, it covers every record of every activity done by the company. Like you people study setting up of business subject, in that you have labor laws, right? In that you must have studied that chapter prevention of sexual harassment at workplace, right? Now in that, excuse me, क्या है, मेले में है, चुपचाप बैठ. So in that chapter prevention of sexual harassment at workplace, you must have done that any employee is suffered, has become the victim of any kind of harassment, that employee can file a complaint. Correct? So company also have to give the disclosure how many complaints received in the last financial year, when the complaints were resolved, which complaints are still pending. Understand what penalties were imposed on the company during the financial year. Every detail is there in it. So just imagine if company is not taking care of compliance. Okay, so company also have to give the disclosure about the penalties imposed on the company. And now understand, what is the expectation, that investors should read all these documents before making investment. You will come to know about every detail of the company. But what do you think, like annual report, if I say in class, in our regular lectures, I open one annual report in class, real annual report of Tata Motors, like it is around 400 pages. Now just imagine who will read that 400 pages before investing. But actually people who invest a bigger amount read all this, what happened during the year. Are you getting the point? So that way it is. Yeah, you can read that, but if you want to invest, like for example, if you want to invest 5 crore rupees, so obviously you will think first, correct? So every detail is given in it. You can understand, all CS executive students can understand entire board report, entire annual report. That is my opinion, and my opinion is absolutely correct. That is the reason I take out a real annual report in class and I discuss it in class, to give you that confidence that you people are very much eligible to read all this and understand all this. It covers everything whatever you people study in your syllabus. Multiple things, like for example, we did section 186, intercorporate loans. So in that case, company is borrowing money or giving money? Giving money. It's intercorporate loan, we are giving the money, right? So in that case, you will also see disclosure under section 186. So company gave, so 186 is about what? Intercorporate loan, investment, guarantee, security. So when you see the real board report, annual report, you will see there the name of the party to whom the transaction is done, with whom the transaction is done. So name of the party. Then you will see what type of transaction is done, whether it is loan, investment, guarantee, security, what it is. You will see the nature of transaction. Then you will see the amount. Understood? So all these details you will see in it. And when you read that heading, disclosure under section 186, you all will get connected because you have studied that. Provided you have studied that. If you have not studied that, you should have attended Sanjivani lectures at least. Obviously Sanjivani is useful. See, I'll tell you something. All students don't have that much privilege, and all students don't have that much facilities. All students don't cannot afford to pay fees to the classes and all. There are so many students across India who are who rely on such type of revision series. It is freely available. Okay, so and it is just before the exams. So if student gets a good revision series, it is very much helpful for them. So if you all also, if you know your friends who cannot pay fees anywhere and who rely on such revisions, and if you think that this revision was useful, you can share the link to them. Believe me, there are many students who are in search of such revisions. So they will they will thank you like anything, because many people cannot afford that. So this YouTube channel, all this medium are for this only, to provide that type of free service to all the students. Okay, I hope I answered the doubt of Kamna in very much in detail. Okay, chalo, let's go. You studied that 197. What was 197? Overall remuneration. Remuneration 197. Total remuneration company can pay is 11% of net profit, the maximum what company can pay. Then we will did individual limits. Your board report contains the attachment for this also. Yes, once at the end of the board report you will see the attachment number 1 is remuneration. Yes, kisko kitna diya. Then we talk about sitting fees, the amount of sitting fees paid to the directors. So you will see the names of directors, the number of meetings conducted in the company, dates on which the meetings were conducted, whether this particular director attended that meeting or not. Total meetings conducted 9. He was present for 7. Means he was absent for the other meetings. Sitting fees paid to him this much during the year. Everything is given. Then we were talking about this chapter. In the last lecture we revised that chapter, board composition. In that chapter we did types of committees. There was one line, composition of the board committees shall be disclosed in the board report, forming the part of annual report. So who all are there in your audit committee? Who all are the parties of the company who are a member of this committee? The list of parties are given there. Then we say that there is one chairman of each committee. So all these members are a part of audit committee. Okay, who is the chairman of this committee? Even that party's name is given. Everything is disclosed in it. See, it is made by the legal team, because you need to take care of compliance of everything. So why CS is in demand? Because of all such compliance requirements. Do you know something I read somewhere? Like, obviously now, unfortunately, we don't have that person right now in this world, Mr. Ratan Tata. I read that somewhere in one book. Mr. Ratan Tata himself used to read the entire annual report 4 times before it is made public. 4 times. Okay. And that one annual report is of around 400 pages. 4 times. At that age, to see everything. Now understand, we have only 4 papers to study, to give one group in your December attempt. And your age is what? Not even 1/3 of Mr. Ratan Tata's age, right? But still we can't study that 4 papers. But I know now this Sanjivani series is very much helpful for you, so please keep watching, keep learning, keep revising and give your exam. Huh? Sorry? Like, share, comment. Okay, this fellow Kushal, right? Kaushal is telling everybody to like, share and comment. They will do, don't worry. Subscribe also. Okay, subscribe also. He's telling you to subscribe. Can you see how we are managing indirect marketing? That was our game plan actually. Okay, fine. Chalo, let's go. Now what is next? Section 62. That is about further issue of capital. And the first one is right issue. Come on. Now you know what is right issue? The meaning of right issue, everybody? This is an offer made. Is this right issue means what? It is right issue of shares, obviously. So is this right issue the shares given free of cost? No, it is not free of cost. Sorry? No. This is an offer made to the existing shareholders. That's it. Issue of shares at discount is not allowed. We did that already. That is given in sweat equity. Exception was sweat equity for issue of shares at discount. This is offer given to the existing members of company. So according to you, you tell me, अरे इतना जल्दी डर गया तो पूरा लेक्चर अटेंड करता कंपनी लो तो क्या होता तेरा मतलब मैं ऐसे डांटता वाटता गुड नोट पे अपन देर आर आर्ग्यूमेंट्स गुड नोट पे होता है कि नहीं ऑल दोज हु अटेंड रेगुलरली क्या क्या I asked you, can private company issue shares to unknown person? But मैंने आपको डाटा नहीं था. That was my style of explaining the thing. Experienced people. But हाँ हाँ वो तो ये लोग का assumption है. मैं कभी किसी को आज तक मैं कैसे डांटूंगा. हाँ वो अलग तरीका है बस बाकी डांटना कभी आता ही नहीं. करेक्ट. चलो right issue. So it is issue of securities by giving offer to subscribe the shares to existing shareholders. Offer is made to the existing shareholders, correct? First point is done. This was meaning. Second, when this offer is made to the existing shareholders, this offer shall be open for a period of 15 days minimum and maximum 30 days. Again, this is inline of your module. Everyone, very simple. Okay, so meaning is done. Then offer shall be open for a particular period of time. Minimum period for which the offer shall be open is 15 days and maximum period for which the offer shall be open is 30 days. Okay, now point number 3. Now again here we are making offer not to the public but to the existing members. Therefore we are not going to issue prospectus. We are going to issue what? Letter of offer. So letter of offer shall be sent to all the members of the company, right? And it shall be sent, it shall be dispatched at least 3 working days before the date of opening of offer. It shall be dispatched at least 3 working days before the opening day of offer. Okay, yes, here suppose if you all are the existing shareholders and company is giving you an offer to subscribe our shares to make more investments in our company, right? Now suppose if you don't want to invest, can you give this right to someone else? So in this case, yes, here you have right of renouncement. Right of renouncement is given to the existing shareholders. So you can renounce this to anyone else, but that person cannot further renounce it to anyone. You understand? Further renouncement is not allowed. You understood? Suppose if you're selling, do one thing, give this offer to someone else. So if you are giving it to someone else, that person cannot further renounce it. Understood everybody? Yes. This was your point number 4. नहीं 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 ऐसा कुछ नहीं. अच्छा मैं समझा. नहीं 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 वो होना चाहिए. राइट इशू इज ओनली फॉर द एग्जिस्टिंग मेंबर्स. वो बराबर है. हाँ अभी मेरे को समझा. तो यू कैन रेनाउंस टू एनी वन एल्स बट दैट पर्सन कैन नॉट फर्दर रेनाउंस टू एनी वन एल्स. ओके चलो नाउ 4th point. This offer can be renounced to the members only. Clear? Yes. 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 to the members of company. Okay, now then further cannot be renounced. He cannot further renounce it to anyone else. Now when company makes this type of offer to the existing members of the company, member will either accept it or will not accept it. If members don't accept this offer or they don't reply only, now what to do? If they don't accept or they don't reply, so in such case the board of directors shall dispose of the offer, and they will dispose of the offer in a manner which is not disadvantage to the shareholders, which is not disadvantage to the shareholders. Easy? Yes. Now in case of private company, this offer can be open for less than 15 days also. 15 days was minimum period for which the offer should be kept open. So for private company it can be open for less than 15 days also, but you need to take the consent of 90% of the members of company in writing. Okay, so how many number of points? 6 points. 15 days. वो मैंने लिखा है क्या? तो मेरे को क्यों बोल रहा है? चलो, let us revise what it is. It is issue of securities to existing shareholders. Offer is made to existing shareholders to subscribe the shares, to invest money in the company. This offer shall be given to the existing shareholders, and the offer period maximum is 30 days. In private company they can keep offer open for minimum less than 15 days also, but they need to take the consent of 90% of total number of members in the company. Okay, then point number 3, they will send what? Prospectus, letter of offer to all the shareholders, all the members of the company. Okay, and this letter of offer shall be dispatched at least 3 working days before the opening date. Then point number 4, right of renouncement is given to the existing shareholder, however they cannot further announce it. Okay, now company can give offer to the members, but member has not accepted the offer or member has not replied only, then board of directors will dispose of the offer in the manner which is not disadvantageous to the shareholders. It's over. Now the same thing when you see from module. Same thing when you see from module. Same thing. Chalo. Firstly, here you can see the meaning is given. What it is. Okay, then conditions. First condition is private company, public company, right of renouncement, restrictions, khatam. So there is nothing new, you can just go through the points. Okay, then it will be done. See the next topic is getting started, that is ESOPs. So anyways, we have less time, you can read that and then read the module. Now after this right issue, next year we have is first preferential allotment and then we have ESOPs. Okay, chalo, what is preferential allotment? This is similar to private placement but not same as private placement. Similar to private placement but not same as private placement. There is difference. After finishing things we will see difference between both. See what it is, everyone concentrate. First, this is an offer given to specific group of persons on preferential basis. This is specific offer given to the specific group of people on preferential basis. Private placement was also the same thing. Offer made to a specific group of people. Same here also offer made to a specific group of people. This preferential allotment is other than ESOPs, other than private placement, other than right issue, sweat equity, public issue, and what is this DR? Deposit receipt. This is other than all this. Okay. So what it is? Offer made to a specific group of people. Now, what type of securities can be offered in preferential allotment? So shares and securities which can be offered is equity shares, convertible debentures, partly or fully, okay, but not preference shares. Preference shares cannot be offered in this manner. Then, in case of listed company, company will comply SEBI LODR regulations also. Okay, then point number 5 is company is required to pass SR in general meeting. For the general meeting, notice shall be accompanied with explanatory statement and authority must be given in AOA. Everybody understood? Authority must be given in AOA and SR. Easy? Okay, for preferential allotment, securities can be issued for cash and also consideration other than cash. 1 minute. We are not saying that people can invest money in cash. We are saying that this type of allotment, preferential allotment, can be done for money and also for the consideration other than money. Okay, you know what? In private placement, there was nothing specified about consideration other than cash. That means in private placement, it should be only for cash. Here, it is for cash as well as consideration other than cash. Cash only, yes. Okay, this is the difference. Then, preferential allotment. It must be completed within how much time? 12 months from the date of passing SR. Allotment must be done within 12 months. If not completed in 12 months, then company is required to pass one more SR. Okay, one more SR. Then, what shall be the price of securities? That shall be determined by registered valuer. Okay, now see, if we are going for preferential allotment, if we are going for what? Preferential allotment, suppose if we are getting cash in return. So if we are getting cash in return, that's okay. But if we get consideration other than cash, then the question arises. Suppose, firstly, whatever consideration you get by doing preferential allotment, first you need to see the value of that something in return is in line with the securities which are allotted. Means company should get sufficient adequate consideration. Now whatever company is getting, that can be in the nature of asset. Yes or no? That can be in the nature of asset, that cannot be in the nature of asset. Both possibilities are there. Example, if company is making preferential allotment and in return company is getting some property, company is getting intellectual property or any other asset, right? Any property. So that is in the nature of asset. Means company has made preferential allotment and in return company is getting some asset. So whatever company has received, where that will be recorded? Where will company record that? The value of that property shall be recorded where? Company has received that in the form of asset. Correct? So yes, that shall be recorded in the balance sheet. The value of such consideration shall be carried to the balance sheet in accordance with the accounting standards. Easy? Okay. But friends, what if company has received some services? Company is making allotment on preferential basis, but in return company is not getting asset. Company has received some services from someone. So instead of paying fees, we are making the allotment of securities, preferential allotment of securities. So can I say indirectly we have received the service and instead of paying the fees, we are making preferential allotment. Means can I say we have made the payment of that fees? Yes. Can I say that means the expenditure of those services was adjusted with the allotment of shares? So that means if whatever we are getting that is not in the nature of asset, then the value of such non-cash consideration shall be treated as what? Expense in the as per accounting standards. It shall be recorded as an expense. Yes. Understood? So this is the thing, and here is the difference between preferential allotment and private placement. So obviously sections are different. Then private placement, it should be only for cash. Preferential allotment can be for cash as well as consideration other than cash, right? Then in private placement it was 200 persons. Here it is no restriction on the number of allottees. Done. So this is your right issue and preferential allotment. Unfortunately, we couldn't finish the chapter. 1 minute. Huh? I know, but I have to reach Borivali. Okay. See, ESOPs baki hai. ESOPs. Then this is ESOPs only. ESOPs. Then see what is left. ESOPs. Listen to me. ESOPs. 61, 66. 61 you have done this MOA AOA. Alteration of share capital. Okay. 66. That is what is reduction of share capital. And this is the procedure of. See, this is the procedure. You can follow the points. 13 points procedure is done. NCLT approval procedure. And then buyback of shares. Okay. After buyback of shares, chapter is over. And what is left is types of prospectus. So ideally we have covered good number of topics in this chapter. What is left is 61, 66. 61 is already done actually, but okay, it is part of this chapter also. 61 is alteration of capital clause, which you have done in MOA AOA chapter. So 61 is left, 66 is left, then buyback is left, then ESOPs is left, and sweat equity is left, and types of prospectus. This many topics we couldn't revise, but I hope whatever we have revised was in detail. Everything was done. Yes. Mm. So will you manage this? Or you can watch the previous Sanjivani, in that you will find this chapter share capital. Okay. So done? Fine then. So all the very best to all the students. Give your exam nicely, but before giving exam, give your prelims. Okay, prelims at JKSE will start from 7th of December. All students across India can give this prelims. We will post the timetable on YouTube post section also. How you can give prelims and all the details will be given there. Okay, so kindly please prepare yourself nicely before prelims. Okay, MOA AOS. I will record it. YouTube. We will post that on YouTube. Don't worry. Okay, so all the best everyone. Thank you so much. All the best. Please share all Sanjeevani lectures to students who really need it, all subjects. Prelims will be online also, offline also. Both options are open. Okay, we will share the details. Hmm? Sorry? Obviously, हमेशा होता है. Okay, chalo then. Bye bye everybody. Thank you so much. All the best. Thank you.